Just a reminder to everybody in the room, of course, to silence your phones. We do have an informal policy here at the Montana Public Service Commission that if your phone goes off during a hearing, you have to buy donuts for everybody for the next day. We will just note, and we'll name him by name. We are waiting for Mr. Mike Uda to appear. All right. Good afternoon, everybody. The time is now 1:04 p.m. I would just note for the record that Mr. Uda, counsel for Broadreach, is not in the room, but we are going to proceed without him at this point. He was aware of the time start. We had left off with Northwestern Energy presenting its settlement witness, Ms. Lael. Ms. Lael, would you like to come back to the witness stand, please? All right, Ms. Heim.
Thank you. Ms. Lael, can you just to kind of level set us again as we start this afternoon, describe why you believe the settlement is fair and reasonable?
Sure. As we walked through before lunch, the settlement covers the foundational issues of revenue on which certain parties filed testimony. Between our filed case and bookends with that, between that is, I think, a reasonable compromise on those issues. It covers the details of how that revenue amount was determined. It covers how then that revenue is allocated to customers. And then also the broader policy issues that were raised in this case. And I believe that's a just and reasonable settlement. All the parties that were in the settlement filed detailed testimony as to the data that we presented. And the settlement represents a compromise amongst those positions.
Ms. Lael, is there anything in the settlement that guarantees Northwestern a profit?
No, earlier today, you heard Ms. Trinnell in her opening indicate that we have guaranteed profit. And I thought that was interesting because we do not indeed. Critically, we have the premise of utility rate making, right? We can't change our price to customers absent working through a regulated body because we do have captive customers. The key piece there is you grant us the opportunity to earn a return. That does not in any way guarantee it. And of course, we make filings with the commission annually that show how we actually did against our authorized return and that opportunity. And you would see consistently over the past few years that we have under earned our authorized return. So it is indeed not guaranteed.
Can you estimate the residential bill impact for the increase in the electric base rate? How that increase will translate?
Sure. The settlement agreed to here from an electric base rates, and we use residential as the kind of proxy for impact. And you've heard and we'll hear a lot more on how that allocation works. So it isn't the same across classes. And you heard about the subsidization that exists within that, but it's about $8 from current rates that residential bills will increase. And I think it's about $11 from what would have been rates before we filed related to that base rate portion for the electric side.
And can you provide the commission an estimate for the natural gas base rate increase also?
On the natural gas side, the adjustment from both current rates and original filed, smaller amounts there, but about $4 in total to natural gas customers.
Will the rates resulting from the stipulation be just and reasonable in your opinion?
Sime?
I believe that in her expertise as the chief financial officer, she can opine on whether from that perspective, the rates are just.
Mr. No? I'm going to sustain the objection. I would just note, Ms. Trinnell, that as you know, from having practiced in front of this commission many, many times, that many of our witnesses do give legal opinions as part of their testimony. As I have explained to other legal counsel, we are not in a position where you're presenting before a jury, you are presenting before the commission. And so we are able to wade through legal conclusions, but I will sustain the objection at this time. Go ahead, Ms. Heim.
Ms. Lael, can you let me strike that? Sorry. Ms. Lael, are the rates resulting from the settlement, in your opinion, serving the public interest?
Not an attorney, don't play one on TV, but I believe they are in the public interest. And I would go back to the facts that support the case that ultimately utility rate making, it's highly complex, but the gist of it is our costs to actually serve customers, the assets that are serving customers, times of return. And then we and other parties go through those costs in detail and come to a compromise position. And I believe that results in, and what the settlement results in, is a reasonable outcome.
That's all I have for the witness. I would tender Ms. Lael for cross-examination.
Thank you, Ms. Heim. All right, before we go to cross-examination, it's my understanding that the settling parties have agreed that they will not cross-examine each other's witnesses. Is that correct? I get verbal
Yes,
confirmation of that.
Mr. Chairman, that is correct.
All right, I see a lot of head nods out there in the audience, so I will take that as a correct. All right, then in this case, let's move on to non-settling parties for cross-examination. I just sort of sketched out a order, no particular order, but we'll do it orderly. So we'll just run through the same order every single time so everybody knows kind of when they're going to be up next. So 350 Montana will be first, HRC will be second, Broadreach will be third if Mr. Uda ever decides to return. Renewable Northwest will be fourth, and MEIC will be fifth. That's not a comment on the merits of their positions. It's just an order. All right, Mr. Nell. You're a witness.
Good,
Can
good
you-
afternoon.
You're welcome to use this one too if you'd like, or Mr. Uda's.
Oh, I feel like oh, you want me? Well, I prefer to work from where my stuff is, if that's all right.
Whatever you're most comfortable with.
The commission, okay with me? No, I think I'll just do this. Ms. Lil, you talked a lot about this morning and about the settlement reflecting discussions among the parties. Before April 3rd, when the settlement was filed with the commission, Northwestern had never talked to HRC about the settlement, had it? To your knowledge.
To my knowledge, the non-settling parties were reached out to the day the settlement was filed.
So my question was, before that day, Northwestern had never talked to any of the parties about the settlement, had it?
I'm not aware of all the conversations. I certainly had not.
Okay. So when you talk about this settlement reflecting a compromise and, all of the discussions that went on, the non-settling parties didn't even know there was a settlement being discussed, did they?
Objection. I don't think this
Do you
witness,
know?
this witness can't talk about what the other parties knew.
Do you know?
Oh.
Ms. Lil,
Hold on, Mr. Null.
sorry.
Okay, I'm going to sustain the objection, but
Thank
you know where you're going with your next question. Please
Thank you.
proceed.
Thank you, Mr. President. Ms. Lil, do you know if any of the settling parties even knew if there was a settlement discussion happening?
I know that we've settled our last rate cases that I'm aware of, and I know that the settlement timeframe was noted in the procedural schedule. So certainly those conversations were available to anyone who wanted to reach out and who provided direct testimony on the issues.
That's not my question, Ms. Lil. My question is, do you know whether any of the non-settling parties were even aware of the fact that a settlement discussion was being held in this case?
I cannot speak to what you were or were not aware of.
How far along had the settlement proceeded when you first reached out to the Consumer Council?
Objection to the extent that it reaches into conversations privy to Rule 408.
Noted. Go ahead.
Thank you, Mr. President. When did you first contact the Consumer Council about this settlement agreement?
I don't know the particular day. I do know that once our rebuttal testimony was filed, that sets the final revenue number we would ask for. And that shortly after that, we engaged all the parties who provided direct testimony on revenue requirement, which are the ones that settled here today in settlement discussions.
Did you talk to the Consumer Council before or after you had discussions with the large customer groups?
I would say it was about the exact same time that we all started talking.
Okay. If you look at the settlement agreement and paragraph 1 of that, do you have that in front of you?
Yes.
Okay, and in paragraph 1, the increase on the electric side is what? And I'm just specifically asking about the $67 million. What is the increase on the electric side there?
So I think row 3, Northwestern shall be authorized to collect an overall base revenue requirement increase of $67,377,467 for electric service.
Okay, and that's the total operating income that's required for Northwestern for its electric, on the electric side of the house, if you will, in Montana, correct?
That is not operating income. That is the increase in revenues we are agreeing to in this case.
Okay, thank you for that clarification. I guess what I want to get to is that's for all of the electric side of the house in Montana. Is that right?
T&D and the fixed generation services, yes.
Including Colstrip, correct?
Yes.
Okay. So if you look at paragraph 3 of the settlement, and in there, the ROE is, I think you said earlier, that's what's already in place, correct?
Yes, what I refer to in paragraph 3 is the 965 from an electric perspective and the 955 from a gas perspective. And of course, the exception that exists within Colstrip Unit 4, that none of those amounts changed from rates currently in place.
Okay. And Colstrip is currently at 10, right?
Yes,
And what is the capital structure for Colstrip?
I don't have that in front of me.
Does 50-50 sound right?
I don't have it in front of me.
Do you know what the authorized debt on Colstrip is?
I don't have that in front of me either, and I don't think that's in the settlement document,
Okay.
nor would it be.
It's not in the settlement document, but the 67, I'm sorry, I'm gonna up here. Diego, can you just- Oh, it's take down. Okay, I wanted to just draw on here.
Ms. Trinnell, can you give us 2 minutes, please?
Yes, and I can change.
Okay, we're
my-
going to go off the rec for 2 minutes, please. Can you make sure it's working?
Are we good? Thank you.
Okay, time is 1:16 PM. We will go back on the record. All right, please proceed, Ms. Trinnell.
Thank you, Mr. Chairman. So in the settlement agreement, you're saying that you're going to, Colstrip's at 10, this 67 million that we're going to get an increase for includes a cost for Colstrip. So if we look at what the costs of Colstrip are, we'll do debt, equity, and the capital structure in the Colstrip docket was 50-50. You have any reason to question that?
I don't have it in front of me, so I can't speak to it.
Okay.
Mr.
You're
Chairman,
the vice president of,
Hold on, Ms.
what did you
Trinnell.
say your title
Sir?
was?
Hold on, please.
Mr. Chairman, we would object to the extent that any of this questioning goes beyond the scope of the settlement, which is the only scope in front of the witness right now.
Mr. President?
Yes, go ahead.
The settlement is asking for an increase of 67 some million dollars, and this line of questioning will show that that should be reduced by $3.5 million.
I'm going to overrule the objection. Go ahead, Ms. Trinnell.
Thank you, Mr. President.
I would just state, of course, though, that please don't, when we get into future witnesses, please don't run over the same ground then.
Thank you, Mr. President.
All right, go ahead, Ms. Trinnell.
And so you, as we noted here at paragraph 3, we're going to keep Colstrip at 10, right?
Colstrip remains unchanged. That's correct.
Okay. And the cost of debt of Colstrip is 6.5%. Do you have any reason to question that?
I'm gonna.
That was
object.
authorized?
There's no facts and foundation on the debt of Colstrip. She asked the witness doesn't have it in front of her. If Ms. Trinnell has documents or something to lay the foundation for that fact.
We
Ms.
can,
Trinnell,
yeah, we can look at her deposition testimony, Mr. President. I'm happy to go into that.
Her deposition was not taken in this docket.
And we can look at the Colstrip order, which this commission can take administrative notice of, in which the cost of debt for Colstrip was set.
If she could put that in front of the witness, that would be.
It's order 6925, paragraph 264 in the Colstrip docket, which was a 2008 docket. I don't have the final order in my hands, Mr. President.
you what? Ms. Trinnell, do you have anything for the witness to
I
review or
do.
work off of?
I do. Actually, you know what, Mr. President, if I may, I'm going to offer this exhibit now. I was going to wait and go through it with the witness, but I'll do it now. May I approach?
Of course.
And this is marked as 350 exhibit 21.
Can we have her lay the foundation before she starts asking questions about it?
Hold on, Ms.
previ-
Heine, please.
It was not previously identified or provided to the court report. Or the party.
Mr. President, if I need to get a copy of the Colstrip final order, I would ask for 5 minutes to go do that. I don't have it in my stack of papers that I have with me here today.
I'm referring to the exhibit that you just put in front of the witness, the commission and the parties that was not identified in your pre-hearing memo or distributed to the court reporter or the parties. with your other exhibits.
Right, Mr. President, I was just going to walk through the data that supports where I'm going with this line of questioning.
All right, everybody hold. All right. First, Ms. Trinnell, please provide a copy of this to the court
Oh,
reporter.
I'm sorry. Thank you.
Start there.
Thank you. Great, thank you. Okay. So, Mr. President, I'm attempting to walk through a line of questions predicated on public documents that I was operating under the idea that I would be able to ask Ms. Lael questions about Colstrip and the cost of debt, which is something that has been gone over for 15 years fairly repeatedly. I'm happy to get that information, which is here at the commission, online, all over the place. The order and the paragraph number are in that exhibit that I just distributed, but I would need a short break to do that.
We are, Mr. Trinnell, going a little far afield of the settlement agreement terms. However, well, I'm going to allow you some leeway in this matter. You will lay some foundation for this initially, then Ms. Heim, I will hear from you.
Thank you,
And
Mr.
then
President.
And we will go from there.
I appreciate the concern. I will say that the increase in the revenue requirements that Northwestern is requesting of 67 million includes, as Ms. Lael testified, the cost for operating Colstrip. This line of questions is directed to show that Northwestern is in fact generating $3.5 million more on the debt of 6.5% than we pay on that debt. So it is very much directed precisely to the settlement.
All right, please
Thank
proceed.
you.
Go ahead and lay foundation.
Thank you, Mr. Okay, Ms. Lael, are you familiar? Does the fact that the debt at Colstrip is 6.5%, does that sound familiar to you? Is that something that you've seen over the years?
You have it on this sheet, yes.
Okay.
And
Thank you.
I don't know if I should just cut to the chase, but the 67 million does not include a change in capital structure. So just when you phrase it, that the $67 million increase you're challenging here includes an increase related to this, I think you're aware that there is no change to the Colstrip capital structure in this docket. So there is no increase in the 67 million related to that.
Okay, great. Thank you, Ms. Lill. I really appreciate that. And I'm going to ask you a couple of questions on what you just said. Okay. So you're not asking for
Ms. Trinnell, did you want to mark this document?
Or
The
lay the
doc-
foundation for it first?
the document that I just circulated is marked as 350 Montana Exhibit 21. And I will move for its admission, Mr. President, but I was going to ask Ms. Lill a couple of questions on it first. Okay.
Would you like to lay the foundation if she knows what exactly this is that she's looking at, please?
Well, Mr. President, I was going to lay the foundation as to each separate component that's contained within the document so that we can substantiate. And Ms. Lael just said, what her testimony I think just was, that the settlement doesn't change the capital structure of Colstrip. And so I was going to ask about that. And as we build the component parts of this exhibit, then I would move for its admission.
Sign.
So in my experience, it's inappropriate for a witness who did not create a document to be used to lay the foundation for it, or for it to be moved into admission.
Objection noted.
Mr. President, Mr. Chairman, it's been brought to my attention that the final order from Colstrip is actually in the record. It was attached to Northwestern's response to LCG 4, and that was moved for and admitted. So that would be already in the record.
Sign.
I would still like the witness to have a copy of it in front of her. She's going to be asked questions about the order.
I believe
I would also note that Ms. Trinnell made an objection about this witness not being an attorney.
Shall we get
That- Ms. Lael, you do have a copy of this document in front of you, do you not?
I have a copy of a document prepared by someone. I don't believe it's the Colstrip order. But you can ask me questions about apparently something somebody else prepared.
Can
Give
we
it a
get the
whirl.
copy of Northwestern's response to LCG4, which is the Colstrip decision?
But again, I don't think this is the order, right?
No, that's not the
This
order
is
itself.
your own prepared work paper by one of your witnesses.
Well, it cites to the order to paragraph.
So
60.
we are going to take a 5-minute recess. We're going to try to get this worked out at this point in time.
Thank-
Time is now 1:26 PM. We're going to go off record.
Thank you, Mr. President.
Time is now 1:32 PM. We are back on the record. Where we had left off was we had a discussion about what's been marked as Exhibit 350 Montana Exhibit 21. There were objections made as to foundation for this document. Chanel.
Thank you, Mr. President. We have emailed around a copy of the order in docket 2008-669, order 6925F. That has been emailed around to the group. I have it open in front of me right now, and I would ask to put this in front of the witness.
Fine.
And for purposes of the record, I would mark that as 350 Montana Exhibit 23 and move for its admission.
So hold on, Mr. Note. So I'm going to ask you a question. Who prepared Exhibit 21?
Mr. President, I've put this together based on the data from this docket, the settlement and underlying orders as footnoted on the exhibit itself.
So you prepared this document?
I did.
Sign.
We would object to this document. This is the first time that we've seen it in this docket, and we have not validated any of the data. For example, it's footnoted at the top that all of this comes from Ms. Lale's testimony. And yet I don't think it does. And it certainly does not come from the settlement itself. So perhaps to the extent that this comes from Ms. Lale's testimony, we can readdress it when Ms. Lale is recalled to talk about her direct and rebuttal testimony. Would give us an opportunity to actually look at it and for a better foundation to be laid. But generally, I'm not a fan of this type of exhibit, which is a composite made by somebody else and asked to be validated by a witness.
Mr. Chanel.
I was not going to move for its admission, Mr. President. I was going to walk the witness through the data that supports this. And I was asked when Ms. Lale said she wasn't familiar with the debt on Colstrip, we got a little bit hung up on getting the data support underlying that. And so I offered that summary exhibit, which we can use just as a demonstrative exhibit. If that solves the problem, we can just use it as a demonstrative exhibit. But I think the purpose in the line of questioning and to expedite things here, Mr. President, I can just continue with the line of questions as I had originally set out, because I've got the Colstrip order in front of Ms. Lale now, and I can ask her the questions about the debt on Colstrip.
All right, Ms. Chanel. So clearly Exhibit 21 doesn't come in because proper foundation hasn't been laid for it. We will proceed under the path you have just now laid forward. Go ahead, Mr. Chanel.
Thank you, Mr. President. So Ms. Lale, you have in front of you that order from Colstrip, which we've marked as Exhibit 350 Montana 23, and I think I moved for its admission. I'm not sure if I got a ruling on that.
We would object to its admission. It has little bearing on the case in front of the commission, let alone settlement.
All right, hold on. I don't have Exhibit 20.
We just emailed it to all the parties.
It's the Colstrip order from the 2008 docket.
That's right, Shannon, that's what it is.
All right, I'm sorry. So go ahead.
So we would just generally object to its admission. It doesn't have well, it's not relevant to the settlement. It's not, she can use it for demonstrative, but admitting it into the record in this docket doesn't make a lot of sense.
I'm gonna overrule. Please proceed.
Thank you, Mr. President. So Ms. Lale, if you look at paragraph 264, the final order in the Colstrip docket, what is the cost of debt that was approved for Colstrip?
6.5% cost of debt.
Okay, thank you. So this 6.5% cost of debt, and what does that first sentence of paragraph 264 say?
The PSC determines the CU4 revenue requirement for the life of the plan should be based on a 10% ROE and 6.5% cost of debt.
Okay, and that's the 10% that you picked up in the settlement agreement and are retaining, correct?
Per the order, I don't believe that could be changed.
Can I take this back?
Sure.
Thank you. Okay. So if we look at what we've got here at a 50-50 capital structure, as we just talked about, for Colstrip, and it's your testimony that it can't be changed. So in the settlement, with the ultimate 67 million that you're asking for from this commission, that is 6.5, 10% on the 50, and that gets to the 8.25, which is in your exhibit 1 to your testimony. Do you want a copy of that?
Don't believe Ms. Lael put testimony related to the settlement into the record.
Would you like a copy of your exhibit 1 to confirm that this 8.25 is the correct? And that's a copy of your exhibit 1 to your testimony. So this 8.25 for the return for Colstrip is what you have in your testimony, correct? Ms. Lell, do you need to look at your lawyer to answer my
Well,
questions?
she said something. So there is a footnote on this page that shows that. And again, I don't know if there was a question in there earlier, but you made a statement that the $67 million increase contains this. And I just to clarify, it does not.
That's
That
where-
would be a base rate issue, not the increase that you're objecting to.
That's what
today.
we're going to work through with the commission right now. Okay, thank you.
Okay.
So I'll ask questions about that. Okay, so it's do you have a can we get a copy of Rich's exhibit 3? Do you know what the remaining cost on Colstrip is as you sit here right now?
Not off the top of my head.
Okay, so can we get a copy of the exhibit 3 to Rich's testimony? And I have a copy of it right here I can put in front of you.
Rich's rebuttal testimony.
Yes. Yeah, well, oh shoot, whoa. Good. I have a copy of it right here. I can give her, but it's very small.
Well, we would
So I'm
like the-
asking
we would
you
like the
to-
page number so we can also reference it.
I'd have to, it's exhibit 3. It's Rich's exhibit 3,
It's 127
page
pages long.
57.
Thank you.
And Ms. Lael, if you look at row column AS, row 57 down on the bottom, and it's been highlighted. That gives a number that shows the remaining cost of Colstrip. Do you see that number there? 276?
Yes.
Okay. Okay, so if we have debt, equity, the total is what is the exact number there? Can you read it?
The rate base line you have highlighted here is 276,937,457.
937, 457. Okay. And so if we're going to keep the capital structure for Colstrip intact, as you've testified the settlement does, then the debt and the equity of that would just be divided in half, correct?
Yes.
Okay. So you can check my math on this, but would you agree, subject to check, that that's 138, 468, 728?
You'd have to give me a calculator.
Yeah.
I think that's your math, not my math.
Right. Subject to check, are you?
Again, I'll just say that's your math
Yep.
that you're putting
Okay.
up there.
Well,
I
we
don't have a
can,
calculator to validate it.
okay, and we can divide 276, 937, 457 by half and fill in these blanks, right? So 468, 728. Okay, and if the cost of debt for Colstrip is 6.5%, if you multiply that number, you get the required operating income to service that debt, correct?
You get a component of the revenue requirement built up that relates to capital structure. It's not operating income.
Okay. And that all goes into the revenue requirements that you're asking the commission to approve in the settlement, right?
Yes.
Thank you. Okay, so if we multiply the 6.5 by this 138, subject to check, the math would come out at just a little over 9 million. And would you look at your testimony at page, do you have a copy of your pre-filed testimony in front of you?
All I have is the settlement.
Can we get a
Given
copy
I thought
of
that's what we were
Ms.
talking about.
Lale's pre-filed testimony, please?
Her pre-filed testimony hasn't yet been admitted into the record. For the record.
Stranell,
I'm just going to ask her a question on it. I'm not going to move for its admission. I mean, I could ask her if she's familiar with it, but this is just for purposes of laying the foundation of this exhibit.
I mean, Ms. Stranell, this testimony is not even in the record at this point in time.
Well, Ms. Lale, if you calculated the long-term debt for Montana, for Northwestern's operations in Montana, right?
I am sure that's in my testimony.
Okay. And if you want to look at your testimony at page 61, you calculate it for the entirety of your Montana operations, correct? Page 61 is where you go through this exercise. And you explain to the commission how Northwestern calculates the long-term debt for purposes of rate making and the revenue that you're seeking here, right?
Yes.
Okay. And it's your testimony that the debt for all of the utilities, Montana operations is actually, in fact, 4.01%, right? That's your testimony?
I believe CDL 61 references statement F and says 4.01.
Okay. And that's also in your exhibit CDL 1, right?
Yes.
Okay. So if you multiply the actual cost of debt that Northwestern actually pays today in Montana times the debt that we actually owe on Colstrip, you multiply 138 million and some times 4.01 and subject to check, that number is,
I'm sorry, Mr. Chairman, I'm going to insert another objection that Ms. Trinell is now actually testifying.
well, I can get a in these cases at the commission that this kind of math happens quite frequently, and it is something that is a back and forth subject to check. And so if we want to have a calculator, that's fine. But to move things along, this is how we've done it for a long time here. So I was just going to finish.
Or to add.
I just think that this is, again, beyond the scope of the settlement and far beyond what this witness was testifying to related to the settlement. And all the pieces and parts don't really contribute to the commission's education.
All right, so as I alluded to earlier in my comments, this is beyond the scope of the settlement agreement at this point in time, but at some point in time, we are going to have cases in chief. And so I'm going to give Ms. Trinell some leeway here. But again, Ms. Trinell, I'm going to say that if you try to cover this ground again, I'm going to say that it's redundant at this point in time. Right. So that addresses that objection.
I understand, Mr. President. I'm trying to be careful and also move along at the same time. And this goes directly to the request that Northwestern has made of $67 million.
I understand, Mr. Trinell.
Thank you.
I'm also going to overrule Ms. Himes' objection as to your essentially talking through the numbers. The objection was is that you're testifying. I would agree with you, Ms. Trinnell, that my experience in 2 years on the commission is we allow attorneys to walk through numbers through witnesses, so that will be overruled.
Thank you,
Please
Mr.
proceed.
President. Thank you, Mr. President. So what we have showing here then is if you take the actual debt costs of Colstrip of 138 million and some change times the actual debt costs being paid by Northwestern for Montana right now, which is 4.01, you get $5,552,596 subject to check. Ms. Leal, do you have any reason to disagree with that?
That's your math.
Thank you. So if you look at the difference of what we're paying right now of a little over 9 million, and you subtract the 5 million of the actual cost of that debt, would you agree that that number, again, my math, subject to check, is $3,444,870? Subject to check, my math. Any reason to disagree that 9 million minus 5.5 million is about 3.5 million?
No.
Okay. Thank you, Ms. Leal. And so if the commission is looking at the entirety of the resources in Montana right now and trying to get a correct snapshot of costs and expenses and revenues and what Montana ratepayers should be paying to their utility for actual expenses, why shouldn't this 3.5 million come off of the 67 million? Since that is not actual money that Northwestern is paying to anyone, right? For its debt.
Again, you have a full settlement in front of you that represents a compromise of positions, and that's not just cost of capital and debt, which you're focused on here. It's the remaining elements of cost of service. It is all inclusive. You heard in the opening statements given here that our rebuttal number was $113 million increase, and we agreed to 67. So you're focusing on one element of that, when I would say the commission's focus is all the evidence on the record that supports the entire $113 million request. And then the settlement here, which is reasonable amongst the parties, which paints the math as to how to get there, but provides 67 million on the electric side for an increase. Whereas you're focusing on one minor element, and inherently in a settlement is a compromise amongst the parties
Well,
after all the facts laid
just
as evidence.
let me stop you, Ms. Leal. So the settlement was that compromise between some parties, right?
Between the settling parties. Yes,
Right.
Mr. Nell.
Okay. And so to the extent that this 3.5 million is an additional expense, 350 Montana would ask that the commission reduce it from the 67 million. We'll move on. Our purpose is evidentiary, not argument. Mr. President, I would like to mark this as 350 Montana Exhibit 24 and move for its admission.
We would object. We don't think it's necessary for the record, but also 350 Montana had plenty of opportunity to include that type of math in its pre-filed testimony and declined to do so.
Are there any other objections? Moving this admission of this. I'm going to sustain the objection. This is a demonstrative exhibit, piece of evidence. It's not a. It's just demonstrative. Ms. Trinnell, you walk through the numbers. All right, Ms. Trinnell, any additional questions?
May I have it in the record as a demonstrative exhibit, Mr. President? And to the point that we had plenty of opportunities, we got the settlement last week.
Ms. Heim,
I would just argue that it's not evidence, and so it should not go in the record. Demonstrative exhibits don't go in the record.
I'm going to sustain the objection. It's a demonstrative exhibit. Ms. Trinnell.
Thank you, Mr. President. I am trying to be sensitive to the direction that I think the commission is intending to go here. So to the extent that there are questions on pre-filed testimony and other substantive issues, I can reserve those and cross that bridge later. I don't want to waive that opportunity. I'm trying to be sensitive to what I'm thinking the commission wants here.
Thank you, Mr. Nell. I affirm what you're saying. Yes, you would have the opportunity to question on the direct testimony at a later point in time. Any additional questions for this witness, Mr. Nell?
I did have a question. I do have a couple more questions. Mr. President directed to the settlement, paragraph 15 in the PCAM and the witness's testimony this morning about what the PCAM is, how it operates, and the idea that the gas plant should come into this case.
Very good. Please proceed.
Thank you so much. Ms. Lael, you talked about the settlement agreement in paragraph 15 being the vehicle for the gas plant. And I would like to clarify, because I think I heard you say something, but I would like to clarify. Was it your testimony this morning that no capital for the gas plant, there's no capital component for the gas plant in the settlement agreement? Is that your testimony?
That is correct.
Okay. So are you telling the commission in this docket that you're not going to seek recovery of the cost to build the plant?
Certainly not. What I'm saying, and maybe we're misunderstanding one another, is in this settlement provides an opportunity for us to come in and seek recovery of operating costs, not capital. So hopefully we understand each other there. Operating only, not capital, with a reset of the PCAM base at that time and a prudence review. I'm certainly not saying I won't ever come in and request recovery of that capital, but that would be subject of our next rate review, if that clarifies.
And when would you expect to file that?
We look at that on an annual basis and determine when we're going to file next. I would tell you, with the amount of investment we're currently making in infrastructure in the state and rising costs broadly, that it'll probably be more frequent than it has been in the past.
Ms. Lael, do you understand the PCAM to be a tracker?
It is a recovery mechanism. It is not what I would personally call a tracker.
Whose idea was a PCAM? Do you know?
I wouldn't raise the PCAM as an idea. It was a revision to the previous pass-through tracker that allowed for the recovery of supply costs again on the market and a broader set of definition of cost recovery through that vehicle. It was revised into the PCAM. I don't know whose idea it was.
It was proposed by Northwestern in response to a commission docket, correct?
The commission, yes, requested to revise the current mechanism, and the PCAM as designed here was certainly not. It was, again, a settlement amongst the parties.
Well, the concept of the power costs and credit adjustment mechanism was proposed by Northwestern, correct?
I would not agree with that statement.
Okay. In the original docket that was responsive to the legislation that made cost tracking permissive rather than mandatory, the commission asked Northwestern to propose how costs should be tracked, didn't it?
My recollection, subject to check, my memory's not all that good some days of the week, is yes, there was a docket open to examine how to revise that mechanism, and the PCAM as it sits today is an output of that process.
Okay. And as the PCAM was proposed by Northwestern and developed over the last several years, there was never any intent that the building and construction and operation and maintenance of a plant would be recovered through that vehicle, was there?
Again, a couple of things. That vehicle has had a bridge rated in the past. It's been expansive in the past. It's been narrower in the past. What we're proposing here, and again, it's not the building and capital of the facility that will be held till we file a general rate review. It's the operating costs, certain of which have certainly been in the PCAM mechanism before, and other facilities. But this is defining specifically what we expect those operating costs to be and providing a path for recovery of those once the asset is serving customers.
Would you agree to remove paragraph 15 in its entirety? Should the commission find that the PCAM is not designed as a vehicle for recovery of costs for the gas plant?
No.
Mr. President, as far as the settlement itself goes, I do want to just be transparent that I do have questions about regulatory lag. But I think that those are better reserved for the case in chief when Northwestern gets to that. So I'll move on. I'm finished with questions on the settlement for now.
Okay, thank you, Mr.
Thank you,
Nell.
Mr. President.
HRC.
Afternoon, Ms. Good afternoon, Ms. Whale.
Good afternoon.
Can you all hear me?
Yes.
Okay. So I want to begin just by asking if you agree with a couple of the characterization on a couple of points that Mr. Nelson made in his opening. Were you here? Were you present during his opening statement?
Yes, I was.
So Mr. Nelson stated kind of that if the commission agrees with the settlement insofar as it relates to the recovery of PCAM costs, I'm sorry, if as it relates to the recovery of Yellowstone costs in the PCAM, that let me restate it, try to make it a little more coherent. If the commission agrees with the settlement, then the provision in the settlement related to the ability of Northwestern to recover moral costs through the PCAM does not bind the commission to anything. And if I could try to restate it once more, that provision in the settlement agreement in paragraph 15 was simply an agreement among the settling parties as to Northwestern's ability to seek recovery of those particular cost items through the PCAM, namely that they would not oppose Northwestern's effort to try to recover those cost items through the PCAM, in the PCAM, but that if the commission approved the settlement, it was not being bound to authorize the approval of those particular cost items. And as Mr. Nelson put it, that would be a decision for a future commission to make. Do you agree with his characterization?
Yes, I think I agree with what you're saying. So I'll restate it slightly
Please.
to make sure we're maybe saying the
Please,
same
please.
things, which is paragraph 15. It's the much talked about paragraph 15 here is a path for us to bring forward a case for the commission at that time. I think Mr. Nelson was making that case that you may have different commissioners at that time, but once the asset is in service, it will be the facts and circumstances that are presented in that case that support the recovery of the operating costs at that time, and that nothing in paragraph 15, nor do I think legally we could, but as we've asserted, I'm not an attorney, could bind the commission's future decision-making in that regard. And I think he made that case very clearly. And I think that's what you're saying.
Thanks. That's correct. Now, Mr. Nelson also said, and this is going to be pretty close to verbatim, so I'm gonna actually read it, and maybe that will make it more intelligible too. That insofar as the Yellowstone costs, the proposal to include Yellowstone costs in the reliability rider and now through this PCAM, that it was an important point that no costs associated with Yellowstone were recovered from customers until Yellowstone was built, until it was deemed prudent, and until it was put into service. You agree with that proposition and Mr. Nelson's characterization of the principle that the settlement is trying to effectuate?
I think I agree with the principle of it. The only slight edit I would make is what we've contemplated here is that around the time the plant is placed into service, we would come in with a filing, and the commission at that time may decide to grant interim rates while it is completing its facts and circumstances prudence review. And so the only edit I would make there, and I don't think Mr. Nelson was intending to not get into the granularity of the detail, but I will here a little bit, is typically you have, as a proceeding progresses, similar to this one, interim rates are granted, but those are subject to refund with interest pending the outcome of that case.
Well, thanks, Ms. Whale. I am trying to get into the granularity, and that was the precise thrust of my question. So you anticipate then, assuming the settlement is approved, coming to the commission in the future and at your next PCAM filing, and again, waiting until Yellowstone is nearly constructed or is about to go into service, and asking the commission for interim rate recovery for those Yellowstone costs, notwithstanding the fact that the commission had not deemed that plant to be prudent as of the time that you are making that interim rate request, and as of the time that those interim rates may go into effect.
Again, I would say interim, so two things, we would make that filing upon approximately the timing of it serving customers, right? And then the key piece there is similar to this filing and any other interim rates when they are granted, and if they are granted, are subject to refund. And certainly if we would go through that process and for some reason that plant were deemed not prudent, then that's a refund with interest, right? So I certainly would expect we would likely request interim rates at that time. But again, these are things that would be taken up in that docket, which I think was the point of Mr. Nelson's comments, was none of this settlement. This simply provides an agreement amongst the parties for how we think that process will lay out in the future, but nothing binds any commission determination at that point.
Right. Okay. Thank you. Let's look at table 1 in the settlement, please. That's on page 4. This is the revenue requirement on the electric side. Just so we're on the same page, settlement calls for a revenue requirement, total revenue requirement increase. So this includes property tax of $81 million, or I guess around $82 million. And that allocates about $44 million of that increase to the residential class. That's with me?
Yes, I'm following you.
Okay, cool. What I want to focus on is the last two columns, I guess the last column on the percent increase. Am I correct that that number, and just for simplicity, we can look at the residential row, is the percent increase in the amount of the revenue requirement that's being allocated to the residential class? Is that what that 18.2% represents?
Yes.
And am I also correct? Am I correct then that that means that rates are going to have to increase by about that much to pick up that increase in the allocated revenue requirement for the residential class?
The only clarification I would make to that is that's the entire increase. And I think as the parties are aware, there was an interim increase granted. And so a part of that is already in what we would call current rates today. But from the rates before we filed, that would be correct.
Thank you. Do you know precisely how much rates will have to be increased?
I'll give you an imprecise answer and see if that answers it. I think the total residential bill is around $11, slightly underneath of that in total for an average residential customer. And I think that's from prior to this filing. And then it's about $8 from current rates, but I'm not the best witness to answer those pieces. You'll hear from both the remaining settling parties and our witnesses on that a bit more.
Got it. Thank you. And you referenced that in your responses on direct to your counsel. Has Northwestern prepared a bill impact analysis?
Yes, there is a bill impact analysis. Don't know if it's been filed or if that's coming with later testimony to be presented, but given I'm not the witness on allocated cost of service and I'm not an attorney.
Right. I just wanted to know if you were aware whether or not Northwestern had prepared it. So just turning back to table 1, what's shown here isn't everything, is it? And by that, I mean, while it includes property taxes, it does not include the increase in the PCAM. Isn't that correct?
That's correct.
And the PCAM base at present is something about like 138 million, roughly. Is that about right?
The through interim rates, it was adjusted to 190 some million, right? But the original base before this is 138, and then the settlement adjusts that to 208 million.
Right. So that also will have to be taken into account in a all-in bill impact analysis, would it not?
Yes, there's substantial, what I would refer to as flow through costs where Northwestern does not make any money. And in fact, we well know we lose money on those things that are adjusted when we come in for a rate review. So we focused on base revenues because that's the area that there's compromise and give and take. The update to both the property tax amounts that we collect through our bill and then the PCAM are separate items, but certainly impacting customers at the same time.
Right. So I guess what I'm asking is that looking at table 1 does not and cannot give the parties, the commission, the full extent of the effect on rates or bills as a result of the settlement. Just looking at table 1.
Yes, that's true.
Okay, cool. Let's see. I have a question now, and these are just kind of clarifying questions about Exhibit C. And you may not be the right person to ask this, and if not, please defer it. And you can just turn to any of the residential pages on Exhibit C. This is electric. Again, just focus on the electric here. So page 1, page 2. So are you there?
I am.
Cool. Generation adder. What's that?
I think I know this answer, but at the risk of getting it wrong, I would defer you to the right witnesses that understand this Exhibit C and D. And so I think you'll hear from Ms. Fang later.
And that would be Ms. Fang?
Yeah.
Okay, thank you. You probably will defer this
That's
one.
I know enough to be dangerous, and I probably shouldn't answer that question, even though I think I know it.
That's fine. Then you're probably going to defer this one too. Exhibit D, and this may also implicate Exhibit C. So if you look at Exhibit D, which is basically the same format as Exhibit C. So if you look at the row headings for Exhibit D, same as the row headings for Exhibit C, it says current settlement dollar change. And then next to the word current and the row heading on the first page of Exhibit D, there's an asterisk. And then if you go to the last page of Exhibit D, you'll see what asterisk means. And what it means is it says current has been adjusted to reflect the stipulated revenue allocation numbers. So I guess maybe two questions. Can you tell me what's going on there? And can you tell me why D is different than C?
I will keep it to my lane, which is I will defer the questions to those who prepared and know these exhibits
Do you have
well.
any idea what the answer is there?
Well, I do, but again,
Okay. that's
before
fine.
I go outside
That's
my
fine.
lane, which my counsel will tell me I'm not supposed to do.
That's fine. That's
The
fine.
ones that actually know that will be available to answer your
That's
questions.
fine. And that's Ms. Fang again. All right. Now, this next question concerns the work papers that were sent electronically late yesterday afternoon. I told the commission earlier that I was going to move for the introduction of those. Those are electronic files. The logistics of moving for the introduction of those are burdensome. I believe I can answer my question without moving for the introduction of those, but those work papers are important. I'll just note. My question then, without referring to those work papers, and
So to clarify, are you moving?
no,
The admission
I
those
am,
at the-
I am not, Mr.
We,
Chairman.
we wouldn't object if you wanted to.
You can introduce them. I will ask my question as is. Can you explain why the GS1 primary class and the GS2 transmission class were excluded from the property tax increase?
So I would again defer and I hate to sit here and not answer your questions, but in the sense of allocated cost of service and that determination, you'll hear from both the settling parties witnesses and also Ms. Fang on exactly those determinations.
I think I want to press you on this. You are the CFO, correct?
Yes, I am.
Do you have any sense, any indication, any knowledge about why these
Sure.
two classes were
Sure.
excluded?
There
from the
was,
property tax
and
increase?
you heard an opening comment, and my attorneys will tell me I shouldn't answer stuff that I don't know, but the gist is that conversation of how you take those revenues and allocate them to classes, both property tax and base rates. There was significant work done on that, as you might imagine, right, amongst the parties. That is not something that is my expertise. And so I rely upon the people within our organization and certainly amongst the settling parties that do that. And so I'm not at all trying to deflect your question. What I'm suggesting is you will have a lot of opportunity to ask those exact questions. And that certainly comes down to class cost of service and the basis with which, right, is the data that you use to allocate that revenue. But that's best asked to others.
Okay, no further questions.
All right, thank you, Chuck. Mr. Uda, you're on the hook.
I don't have any questions, so not on it.
Always concise, Mr. Uda, thank you. Renewable Northwest.
Thanks. Good afternoon, Ms. Lael. Can you hear me okay?
Good
Is this on?
afternoon. I can hear you well.
Again, my name is Barbara Chilcott. I'm here on behalf of Renewable Northwest, and I just have a couple questions for you on the settlement. The first one being, I believe you testified earlier. I guess I'm curious about the timing for filing the next case that you've discussed. I think your testimony earlier was that typically in the past, Northwestern's filed on an annual basis rate cases. And so my question is, and I think your testimony was that'll frequency will increase given cost increases, et cetera. Am I characterizing that properly?
Not quite. I'll
Okay, help me
attempt
out.
a clarification.
Thanks.
Our rates prior to this docket for the electric side were based off a 2017 test year. For the gas side, 2015. So it has been that amount of time since we last filed. My comments were, broadly, there were trends at that time and even previously that allowed us to stay out of rate cases and keep rates consistent. Those included low to no cost of capital, right? When interest rates were basically zero, that was very helpful. Things like tax rates declining, broader inflation, as you've heard here today, being pretty well flat. That allowed us to stay out of frequent rate cases. Those conditions, as I think everyone in this room is well aware, are not the same today. So my comments earlier were meant to say it's likely that going forward, should those cost pressures persist, on top of the amount of infrastructure investment we've been making in the state of Montana, over $1 billion of investment since our last rate reviews. And those are significant dollars. And when we look at the needs on the system, primarily driven by T&D capacity, both electric and natural gas, those are the reasons or the basis of my comment of why I would expect that going forward, you would see us end more frequently for rate reviews.
Okay, thanks. So I guess my question then is really more specific to the one-time PCAM filing that you intend to make for Yellowstone. And so when do you anticipate bringing that filing to the commission and the associated prudence review?
I would roughly say very closely as to when that plant is placed into service. That plant is currently expected to be placed into service sometime in 2024. I think as most of the people in this room are well aware, there's a current challenge to that, but I would expect that we'll continue somewhere in that vein.
Okay, thanks. And then question for you on paragraph 15 of the settlement, the third bullet, where it captures the fixed O&M expenses. My question is, generally for PCAM, one of the 4 criteria used for determining what costs should be included in a supply cost tracker, like the PCAM, is that the costs are highly unpredictable and volatile. So my question is, how do those fixed O&M costs meet that criteria?
Again, the gist of this settlement is the PCAM is a vehicle through which to use. And the construct of this is if we narrow this reliability rider to just focus on Yellowstone and eliminate the capital, the key piece and the key discussion was around incurring that significant of operating costs, which if you add these up, you will see that's substantial to us while customers are receiving that benefit, but not paying anything for it, basically for free. So what we incorporated in here and in the past, the fixed O&M amount, think literally the people operating the facility at the time as serving customers, that's not been in the PCAM in the past. And we would expect this to be a bridge to when we file a full rate review. And at that time, those costs would come out of the PCAM and into base rates.
So the settlement basically expands what the PCAM is allowed to capture then.
Yes, that's fair.
My last question is related to some pending legislation. Are you familiar with House Bill 284 that is moving through the Montana legislature right now regarding pre-approval?
I am familiar with generally the pre-approval bill. When you said the number, I couldn't have helped you there.
Yeah, I get it. So the question is, and this might require some speculation on your part, but assuming House Bill 284 becomes law, has Northwestern considered whether you'll seek pre-approval of Yellowstone under that new statute instead of moving forward with what's been agreed to here in the settlement?
I would answer that in 2 ways. I can't speculate into the outcome of the legislative session, but the key piece of when we pulled our pre-approval docket, which of course is not in this docket, but the necessity to proceed with construction, that inherently the word pre-approval, and this commission was adjudicating that docket at the time, but we needed to give notice to proceed to literally construct to keep the pricing we had at the time. So I don't think inherently it can be pre-approval when you're that far in. And that was certainly the basis with which we pulled that docket to be able to proceed with what we felt was a compelling value from a customer perspective. So wherever that legislation does or doesn't go, we'll consider that, of course, for resources in the future. But this is the path and settlement we've reached with regard to some ability to recover operating costs of Yellowstone once it's in service.
Okay, so it sounds like you wouldn't necessarily abandon this effort that you've come to settlement on, assuming the commission approves it, if House Bill 284 becomes law for Yellowstone.
Not likely.
That's all I have. Thanks.
Thank you, Ms. Chilcott. MEIC?
Thank you, Mr. President, Commissioners. Good afternoon, Ms. Lael.
Can you pull that microphone right up to you, please?
I want to talk first about timelines for the settlement, and maybe we can pick up where you left off with Ms. Trinnell. So the settlement was filed with the commission on Monday, April 3rd, correct?
Yes.
And Exhibit C was filed on Wednesday, April 5th.
Subject to check, sure.
Are you generally familiar with how Exhibit C was prepared?
I think we've kind of had this discussion that generally I'm familiar with it, but it's not the detailed work that I typically do. Other folks within the organization do.
Would you expect, or do you know whether Exhibit C was based off of an Excel file?
Excel is the thing that drives the world apparently. So that's highly likely.
Okay, so that Excel file would contain the information about how the rates in Exhibit C were calculated.
Yes, I think that's fair.
But that Excel workbook wasn't provided to the parties at the time Exhibit C was filed on April 5th, correct?
I think the exhibit was filed as others. I don't know if it's typical if that's filed at the same time.
The work papers, in fact, weren't provided to interveners or commission staff until the end of the day, yesterday, April 10th.
I think that's correct. Yes.
It was provided to commission staff at that time too.
I can't answer that question about that.
Actually, Mr. President, I would like to introduce as MEIC Exhibit 3, the email dated April 10th from Ms. Norcutt to the parties and commission staff. I can forward it on for the record, but I would like to introduce that into evidence, including its attachments.
Let me just ask a clarifying question before I see if there's any objections. The attachments, I presume, would be the work
Yes.
papers.
Thank
Thank you for clarifying. Ms. Heim?
We don't object to the work papers coming in. I think the email itself is irrelevant. Prefer that not come in, just for clarity in the record.
Mr. President, it was provided to all parties and commission staff were copied on that email. It's relevance to this timeline line of questioning that I'm getting at here.
We don't object.
All right. MEIC Exhibit 3 is admitted. Please provide Lisa a copy of that at some point.
Well, thank you. And Ms. Lael, you just testified, I think, in response to Mr. McGraw's questioning that a bill impact analysis has been prepared for the settlement. Is that correct?
I think I testified that there's one in preparation, but that's not my lane. And I think other witnesses will speak to that.
Okay. Were you part of conversations around the preparation of a bill impact analysis?
Yes, the comment I would make is taking those revenues, allocating them to ultimate customer classes, and then determining bill impact is highly complex. So while I am indeed the CFO, that's work that specialists do. And again, you'll hear from a variety of folks on that. I'm just not the person to answer those questions.
And as CFO, were you involved in conversations around the timing of the preparation of that impact analysis?
Again, once we had the revenue determined, that work has been ongoing to be provided to the parties.
Okay, so is it your testimony that commencement of that analysis was around the time the revenue requirement was agreed to.
I think that's fair.
Have you been part of conversations about when to disclose a bill impact analysis to the commission or the parties in this proceeding?
I will go to, I think, the heart of your question, which is the team that does this work has been working steadily on it. It has not been in any way held from the time that it was ready to or not ready. It requires review and a lot of work. And so the timing with which it's been disclosed is as soon as it was ready.
Okay, and you're not testifying that it has been disclosed?
That I don't have that answer. I know it's
So
a
you're
work in
not
progress.
testifying that it has been disclosed?
Can we just clarify, are we talking about the bill impacts versus the work
Yeah.
papers?
Yes.
Can you
Okay.
can you just rephrase the question for a clean record?
You don't have testimony as to whether or not the bill impact analysis.
That's
has been
fair.
Okay.
Yes.
And Ms. Lael, make sure that you allow the legal counsel to finish the question before answering. Go ahead.
Appreciate that.
Okay, yeah. So I understand you don't have any testimony about whether it's been disclosed. Is that correct?
That's correct.
Okay. Thank you for bearing with me on that. Do you agree with me that your stipulation with certain parties in this case does not resolve all of the contested issues identified by the parties in this docket?
I would say it resolves most of them. There are, I think, a couple of issues amongst the settling parties that were not the subject of this settlement.
Okay. And there are also contested issues raised by non-settling parties that aren't addressed in the settlement, correct?
That's correct.
And are there issues that Northwestern raised in its application that aren't resolved by the settlement?
Primary issues are resolved. Again, I think there's a couple of things that we agreed to disagree upon and say for the direct case.
Northwestern's position that the stipulation addresses or resolves the issue that Northwestern raised in its application regarding the impact to Northwestern's financial position due to what the company has characterized as regulatory lag.
I think I commented earlier in my overview of the settlement that it has a limited impact on regulatory lag. Regulatory lag, of course, is driven by historic test periods and how the current commission construct works, regulatory construct works. So this provides some limited support and certainly adjusts our rates based off what we think is a reasonable compromise. But from a broader perspective, we think that work on regulatory construct will continue.
Okay. Does the stipulation, in your view, address the need that Northwestern identified in its application for a constructive regulatory environment?
Again, I think this process and bringing to the commission a reasonable settlement amongst some, but not all of the parties is certainly the case has been constructive as it's moved along. And ultimately the ability to have this full proceeding, bring all of that detail and support for our rates in front of the commission and certainly reach an outcome is a key part to constructive regulatory outcomes.
You confirm for me the stipulation ratifies the company's proposed increase to the PCAM base, correct?
Yes, the stipulation specifically addresses that.
And is it Northwestern's view that the parties to the stipulation agreed to Northwestern's proposal to include capacity contract costs in the PCAM base?
I believe what you're referring to was maybe I'll not guess your question. Capacity costs certainly are included in the overall PCAM base, yes.
Okay. including the category that Northwestern's application characterized as new, the capacity contract costs, forecasted capacity contract costs.
The details of that $208 million base, I would leave to witness Steinmetz.
But
Would
as
be
a
my comment.
category, is the effect of this stipulation to allow Northwestern, if it is approved by the commission, to include such costs in the PCAM base?
Yes, there are costs for capacity in the PCAM base.
The agreement is silent, though, isn't it, on Northwestern's proposal to exclude such capacity contract costs from the 90-10 sharing mechanism in the PCAM tariff?
The way I would state that is, given there is not a specific line item in here that says we have agreed that Northwestern will exclude those from sharing, inherently they will be included in sharing. So that was one of the compromise positions of the settling parties.
Okay. The settlement is silent on the issue raised by MEIC and other parties regarding the coal strip unit 4 rate base. Is that correct?
I would not say it's silent, but I would say it is not specifically called out.
Okay. And how about the issues raised by parties regarding future planning for the coal strip plant? Is that addressed by the settlement?
No, those future issues are not in this docket.
Those future issues were raised by parties in this docket. Are you aware of that?
Yes, there are parties that raised those issues. My comment was the docket was a revenue requirement based off historical amounts and does not include the future of Colstrip in the scope of this docket.
Okay. And so it's not addressed in the stipulation, is the question.
That's correct.
And the stipulation is silent on the risk of Northwestern's approach to the Yellowstone County generating station of deferring a prudence review.
And again, until that asset is ready to serve customers, there are no costs for Yellowstone in this proceeding. And therefore, of course, the settlement is silent to all sorts of things that weren't in this proceeding.
Okay. Would you agree with me in characterizing the settlement as a partial settlement with some issues remaining to be decided by the commission, even if it approves the settlement?
I would characterize it as a settlement of most issues. The primary foundation we're here to determine is revenue, and it addresses those. But I would certainly say it's not a settlement that addresses every single issue raised by all parties in the entire record in the docket.
Does partial settlement sound accurate to you?
Sure.
About the let's see. PCAM a little bit more. Trying not to be redundant here of my colleagues. Paragraph 13 indicates that the increase in PCAM base costs that the stipulating parties are proposing are effective July 1, 2022. And I believe that's consistent with Northwestern's testimony in this docket. Does this mean that Northwestern proposes to collect PCAM revenues retroactively from its customers?
I think when this says retroactive, that's the base that would be applied. Ultimately, we will collect the entire balance there of costs incurred for customers. The base reflected back to July 1 reflects the sharing calculation. The retroactiveness would be that piece, but certainly since that July 1 period, I think we're deferred roughly, subject to check, $50 million. Of course, you guys see those filings every year. So what will actually be retroactive is certainly the costs that have been incurred.
Okay. Over what period of time will Northwestern collect those retroactively incurred costs.
The deferred balance as previously that on an annual basis, so July 1 to June 30, typically that deferred balance does not come in until October 1st. What we've proposed here is move to a quarterly adjustment to that deferred balance, where we would begin, and typically that's over a 1-year period, we collect that deferred balance. We would begin rolling that in so that customers see a more consistent price signal, somewhat similar to the gas side, which is a monthly adjustment. But of course, none of those changes would take place until we see a final order in the docket granting that change.
And will those costs be reflected in the customer bill impact analysis that someone is preparing?
The
for
customer,
settlement?
the customer bill impact will include the adjustment to the PCAM base. I don't expect it will include a projection of what the deferred balance may be once this case is concluded.
Okay. Ms. Lael, I heard you testify on direct that the proposed mechanism for recovering Yellowstone County generating station costs described in paragraph 15 is somewhat of an incomplete solution from Northwestern's perspective. And I believe you said that Northwestern would, the customers would benefit from the operation of Yellowstone County generating station for a period of time while Northwestern is operating that plant. I think your words were for free. Do you recall saying that?
In a slightly different context, yes, I did say those words.
But you're not saying that Northwestern isn't going to seek recovery of all of its costs associated with Yellowstone County generating station.
What my comments were intended to reflect is that the proposal noted here in the settlement provides matching. So of course, the PCAM is the cost that we incur on the market to serve our customers, keep the lights on, right? To fill that gap of we have approximately 60% of the resources we need. We're approximately on the market 40%. And of course, at peak times, that's even worse. So customers certainly see those costs. The time Yellowstone comes online, it will take a piece of those PCAM costs off of the market and be provided by a rate-based asset. But of course, subject to recovery, if that occurs without any mechanism such as this, that's the scenario under which essentially customers would be getting the value of that for free. That was the context of my comments. What this is meant to do is say, at that same time, we would do a PCAM base reset to adjust out of that base the amount of market purchases that would be covered by Yellowstone. But at that same time, you would put in the operating costs for that same facility, that those essentially those market purchases will be replaced by that asset. That's the context of what this paragraph is meant to do.
I may have more questions about that, but I need to think through it. So thank you. I want to go through the categories of expenses here discussed in paragraph 15 as well. First, property taxes, are those typically included in the PCAM tariff?
So property taxes are separately called out here. So
Mhm.
property taxes flow through our tracker mechanism for
Okay.
property taxes. What we're saying here is the base for the property taxes that will begin to be incurred for that facility would be reset consistent with this paragraph.
Okay. And the gas transmission reservation charges that are in FERC account 547, what is included in that account?
So there's essentially it's fuel related costs, which are detailed in the exhibit here, but those are costs that have been included in PCAM previously.
Okay. And is this the same projection, this $8.4 million annually that Northwestern put forward in its abandoned pre-approval proceeding for the gas plant?
I know that it's the costs that are included in ADD 17 in this filing. I can't off the top of my head confirm whether that's the exact amounts that were in the pre-approval filing or not.
Okay. And all of these numbers in paragraph 15 are just estimates. Has Northwestern
Yes, they are estimates.
Has Northwestern done any analysis to update those estimates?
The estimates were included with our direct filing in August, and we have not updated them since then. We included them in the paragraph here to provide some context to the commission in considering this as to the amounts we would expect to be recovering at that time.
Do you know when those estimates were prepared?
I do not.
Do you know whether they are the same estimates as were included in Northwestern's pre-approval filing for the Laurel Generating Station?
I don't know for sure if they're the exact same, but I would expect them to be similar.
Would you expect, as kind of a matter of prudent business practice, that Northwestern would want to maintain kind of updated forecasts on costs such as the fuel costs for the plant?
Again, we've included these for understanding the context of what we're asking for. When we actually make this filing, then you would certainly have the current, as of that date, estimate for the commission to consider.
But internal to Northwestern's thinking, is it your view that it would be a reasonable business practice to understand if those cost estimates have increased over time?
Certainly, I believe the estimates were reasonable when they were included in this docket in August. And as we get closer to the operational date, we will continue to examine those.
Okay. In Northwestern's view, by signing this stipulation, have the settling parties agreed to include all of these categories of costs described in paragraph 15 in the PCAM docket, or to not oppose the inclusion of these categories of costs?
The spirit of this was to include the operating costs through the PCAM once the asset is serving customers. So yes, that is why we spelled them out here, to include what we would expect to file and to make sure that we're all agreeing to the same things.
Okay. And is it Northwestern's view that the agreement of the settling parties not to oppose the inclusion of those costs in the PCAM is contingent on a prudence finding?
This paragraph works together, and certainly the base reset of the PCAM, inclusion of operating costs, and adjustment for property taxes at the same time of a prudence review, that all would occur together. Yes.
Okay. And so the prudence review will commence and Northwestern will make its request at that time also for this one-time expansion of the PCAM base costs, and the settling parties agreed not to oppose the request for a one-time increase.
I think you can ask the settling parties what they believe they agreed to, but I think what they agreed to here is a path for us to make that filing, and that the details of that filing would include those multifaceted things. They certainly, I don't believe, waive their rights at that time to examine the evidence and examine our filing and make whatever arguments in that case at the time that they would like to make. What they have said is they won't oppose us coming in for a filing under that construct.
Okay. But it's not Northwestern's view that the stipulating parties have agreed not to oppose the inclusion of these categories of costs in the PCAM base.
I would say it this way: the settling parties agree not to oppose a base reset. They understand that we fully expect to include these operating costs through the PCAM mechanism, and their case at that time will be examining the validity of those costs, not whether the fixed O&M was meant to be included in there. It's what is in the fixed O&M, and is that reasonable?
Okay. And did the settling parties waive any argument about whether or not the plant is prudent?
Again, the language here says that we would come in for a prudence review. And I don't see anywhere in here where it waives their arguments.
And just for clarity's sake, does paragraph 15 envision that that prudence review will take place in the PCAM docket?
Again, this would be not a lawyer, but an encompassing docket that does three things. It completes a prudence review, adjusts the PCAM base, and adjusts the property tax base. So when you phrase that as the PCAM docket, I would expect this would be a more encompassing docket than that, which contains those elements.
Okay. I have some questions about Exhibit C. I think they're pretty basic. I think so. If you want to defer to Ms. Fang, that's fine, but
I think we've
I'll
already
ask.
stipulated you have to keep it at basic for me, otherwise save it for Miss Fang.
not so. I'll do my best to ask intelligible questions here. Did the parties agree to an allocation among Northwestern's assets of the bottom line revenue requirement in the stipulation?
Could you clarify what you mean by that question?
Yeah, and maybe I can just ask a more specific question. I'm looking at Exhibit C and, the coal strip unit 4 is called out specifically here. And I'm wondering if that was based on an agreement among the settling parties.
What that reflects is the history of Colstrip 4, which we've talked about a fair amount today, having a separate capital structure. So inherently, this settlement determines a revenue amount. That revenue amount is rate base times a return that's stated plus cost of service. And that's how you get to that. So when you say, is it based on assets? Certainly rate base inherently are in assets, and the exhibits A and B give you the math of how that revenue was determined. So you have assets in each of those categories. And yes, that this exhibit C is the very complicated work it takes to get from a total revenue amount, which is built up off of the cost of service and rate base of each of those, be it T&D, fixed generation, coal strip, and what we agreed here into the settlement, and then applying that to these. So it would be based upon the revenue map that's contained in exhibits A and B result in C. And that's about my depth of detail on that. But the separation of this reflects the fact that T&D assets are certainly that rate base is tracked separately from generation assets. And then coal strip unit 4 is tracked separately from a rate base perspective, which we went over today, from other generation assets because of the difference in capital structure.
Okay. Does Northwestern, has Northwestern calculated what its rate base for coal strip going forward will be if the settlement is approved?
The rate base for coal strip in this docket, which is of course the historic test period with known and measurable adjustments, is certainly in the detailed pre-filed direct testimony, along with the rate base workup for all generation assets and all T&D assets.
So it would be Northwestern's intent, if the settlement is approved, to include for accounting purposes in its coal strip rate base all of the capital additions that Northwestern proposed in its application.
Yes, the revenue requirement includes the rate base as stated.
Okay. Is that true for other generating resources or just for coal strip?
That's true for our entire rate base.
Okay.
Over 3 billion, the whole thing, right? The math of the revenue requirement, which is contained in exhibits A and B, say we're adjusting ROE, we're adjusting depreciation, and we're adjusting a broader economic package of other things we disagreed upon, but that's all premised upon the rate base as filed.
Okay, that's helpful. I think that's all I have for you. Thank you.
Okay. Did I miss any parties? All right. So Time's now 2:51. I think all of us are probably ready for a 10-minute break. So why don't we go off the record and why don't we reconvene at 3:05? 2:51 off the record.
Stuff's just falling off now. I'm proud of you, Joe. Okay, good. Was it injury or was it wear and tear? Is it? It doesn't look hard. Ah, is it hard because of the movement or is it hard because of the speed or what is it? Ah, I've never played it, so I don't know. All I know is I saw some like Twitter post where some guy walks out to a football court and goes, "Look how small this tennis court is." There's nothing wrong with playing in an indoor court. We used to rent gyms around town every spring, take batting practice. Of course, we didn't use big balls. But it was just good to get the body moving and get the hand-eye down. I mean, the reason I could do it is like when I was a kid, see a ball get hit, immediately that was. Now it's like I see the ball hit, and then like the second later I start. way over there. Well, the thing is like, you know, I think one of the things I noticed, like, I played the and I noticed that like, well, I was taking those balls, like, you know, and that was a sign. Your right hand is getting in the way of your glove hand. You're not moving right way. I should be having this conversation. Are you? There seems to be a dispute about that. I'm saying I'm not, and my friend is saying I am. And I said, well, you know, all you guys have to do is figure out a way to get down there. And they said, oh, we'll have beer. And so they are. I don't have to play though. I can just go drink the beer as I pointed out to them. Yeah, I mean, the thing is, like, the reason I like playing softball more than anything is just because I got to hang out with friends. 92 degrees. I think the 8:30 games were the best. And we talked to Jim for years about why can't we have the, it's like, well, it'll cost like $10,000. Like, it's an outrage. That's the. Yeah, but the thing is, like, you can spread that cost over games. There's sometimes like the 6 o'clock games, it's just too damn hot to play. Well, I know after the last, what, 7 months of having snow on the ground. No, it's really hot sometimes, Chuck. And it's not even worse during tournaments. It's like 1 or 2 in the afternoon and it's 95. You know, and your pitcher strikes because he thinks he's money not to throw strikes. It's like, that's what I've been doing. It's like, it's all of this. There you go. Well, yeah, I mean, the thing is, though, too, it's like, you know, have you ever played a game where you like have like 3 guys in a row just playing fly out track? Well, we have. Yeah. Well, it was all those terrible games. You know, and I would go like, hey, we're out of punts. Stop hitting the ball in the air. They go, okay. And we would do it again anyway. We had a game check. I'm not making this up. We had 18 home runs for outs. Oh, you know, Jason's starting the fast pitch thing again. I'm sure you got Jason Anderson, my friend. Yeah. A lot of the guys are like our age. Fast pitch is dying faster than safe pitch. Well, how old are you? Right in the 260. Annually.
Commissioner O'Donnell, can you hear me?
Yes, sir.
I think we heard you, Commissioner O'Donnell. Go. Can you confirm?
I'm here.
Okay, thank you.
Can you hear me now? Yes, thank you.
Ready, Lisa? All right, the time is now 3:11 p.m. Go back on the record. We had concluded cross-examination of parties. So we will now move to. Yes, Thor. Sure. I did not enter it into evidence. Any other procedural matters? All right. I did deny exhibit 21 and 24. Any other procedural matters? Seeing none. Time for commission questions. Vice President Fielder.
No questions, Mr. President. Thank you.
All right, Commissioner O'Donnell.
Thank you, Mr. President. Ms. Lael, thank you. In your pre-filed testimony, you made a extensive point, significant point about the outcome of this case and how it would affect the credit rating agency's treatment of Northwestern. And I'm wondering, with all of the issues that you raised, the regulatory lag, the ROE, and all the other things that they take into account, how would this stipulation? How do you feel that the credit agencies will regard this? Is it halfway to what they want? Is it solidifying a good status for Northwestern? Could you help me with that, please?
Sure, Commissioner O'Donnell, the gist of my testimony was where we were at currently and remain from a credit ratings perspective, in the sense of the quantitative metrics for our credit ratings remain below the downgrade threshold for our current investment grade ratings. And the credit rating agencies assess our credit ratings on really two factors, both the quantitative math of what is the calculation of our free cash flows to debt, and then also the balance of qualitative, which is the regulatory construct, predictability, transparency, all of those sorts of things. So your question being, how do you believe, or my expectation of how the credit rating agencies will think about this settlement and stipulation? And I would tell you we meet with them with some degree of frequency, most recently here in March. They pay very close attention to these proceedings and how they're progressing along. They received the interim rate adjustment and indicated that was very constructive with regard to the outcome here. I think it's a fair and reasonable bookends between what we filed and where the interveners who filed revenue requirement testimony were at. And I think they will consider that a positive step forward. And certainly from a quantitative metrics perspective, the adjustments that we're making in this case will be positive to our quantitative metrics as we come out of this.
Well, thank you for that. I certainly understand your feeling they would be favorable, but from the expectations that you put up in your testimony is that what was needed to advance the status of Northwestern in their eyes. I'm wondering, is this like a halfway type of thing? Is this like, well, we tried for more, but we only got this? And would it really be a significant advancement for the company, in your opinion? I know Nobody can tell ahead of time exactly what they're going to do. I think their systems are relatively data-based but gut-based as well, so it's hard to tell what they're going to do. But do you feel that the aims of the company relative to the credit agencies will have been achieved by this settlement?
I would take your question in two parts. One, broadly, the Moody's put the whole utility industry on watch last year because of the kind of macroeconomic environment that we're in of
Yes.
unprecedented rise in interest rates and inflation and all those things and the amount of investment that's needed. But specifically to this settlement, I think the credit rating agencies will view this certainly favorably, that we were able to work with the interveners that filed revenue requirement testimony and reach a settlement, that we put that before the commission. I think they will view the numbers and from a revenue perspective, certainly positive from an FFO perspective, and then the ability to incorporate into the settlement a path forward on recovery of costs related to Yellowstone, specifically the operating costs and the fire plan. I think they will view those very favorably, that there's some element of a future path on those items. I think all of that together, they will continue to work with us and evaluate. Of course, one decision does not make a trend. And so they'll be continuing to watch us closely and watching our metrics. But I think this will be received very positively from a credit rating agency perspective.
Very good. Thank you, Mr. President. That's all my questions.
Thank you, Commissioner O'Donnell. Commissioner Pinochi.
No questions, Mr. President.
Thank you, Commissioner Pinochi. Commissioner Bukacek. Thank you, Commissioner Bukacek. Okay, Ms. Lael, I do have questions for you. You have the settlement stipulation and settlement agreement in front of you, I presume.
I do.
I'm going to spend some time on this. Can you turn to page 24 of the settlement agreement?
Did you clarify? Did you say page
sorry.
4?
Page 8, paragraph 24. All right, you're familiar with this paragraph, I presume.
I am.
I would like to talk about what Northwestern Energy's understanding of this paragraph is. Particularly the last sentence starting with the word if. There.
Yes.
So it reads, if the commission decides not to adopt the proposed settlement set forth in the stipulation in its entirety, then the entire stipulation is void. No party to the stipulation is bound by any provision of it, and it shall have no force or effect whatsoever. Correct?
Yes.
All right. So if the commission does not adopt the settlement agreement in its entirety, what is Northwest Energy's position as to how this matter gets resolved? I presume it would be testimony filed and witness eyewitness testimony.
I would say it this way, that when the parties engage in a settlement discussions, it is a compromise of everything in the kitchen sink. So if you begin to adjust one element of that, it compromises the overall foundation of that settlement, right? It was give and take in the discussion of, if we adjust here, what do we do there? So the things go together, right? So that I believe this paragraph is meant to say that the settling parties believe the stipulation should be approved in its whole. Obviously, the commission has discretion to choose their direction out of this. And if there were any adjustments to the stipulation, then you go back to the facts of the case as presented by each of the intervening parties.
And that's Northwestern Energy's position, correct?
Yes.
All right, let me ask you this question then. If the commission disapproves of the settlement, is it Northwestern Energy's position that the commission should approve each of the 3 riders Northwestern has proposed, or?
Certainly, the way I would say it is we reached a compromise amongst the parties, but if you go back to the case in chief, we believe we raised a strong case for all of the things that we proposed, including most importantly, the revenue adjustment, but then also the criticality of the riders from an operational risk perspective.
At this point in the proceeding, has Northwestern Energy formally withdrawn any of its requests for the 3 riders?
I don't believe so. I think filing of a settlement encompasses our overall position that we're bringing forth to the commission for approval. And we didn't, or any of the other parties, go back and adjust any of our original proposals. What we're presenting is an overall package representing compromise amongst the parties that we believe is fair and balanced.
All right. Thank you for that. Let's go back to your earlier testimony. Clarification question on. So did I hear you correctly? You testified earlier that your property or Northwestern Energy's property tax tracker fails to recover all of Northwestern Energy's property taxes?
The adjustment between rate cases, so the base is reset in rate cases, but between rate cases, it is 1 minus the tax rate. So there's a haircut in there of the property tax amounts.
You have an estimate of what the haircut is?
Not off the top of my head. I don't.
Right, let's touch on a piece that hasn't been touched on. Please refer to paragraph 7 of the settlement. Are you there?
Yes.
Right, this paragraph deals with the acquisition of Sleepy Hollow, does it not?
Yes, it does.
Explain what the settling of parties have agreed to in terms of rate basing and operating and maintenance expenses for Sleepy Hollow.
Okay, I think there's 2 pieces to the settlement regarding Sleepy Hollow, and these are detailed out in testimony that of other witnesses you'll hear from a Northwestern perspective. But the proposed rate base and operating and maintenance expenses reflected in the rebuttal testimony of Jeff Berzina is what we're agreeing to here. And then the deferred cost treatment, I believe that deferred cost treatment referred to, of course, the operations of Sleepy Hollow did not reflect a normal or a full year of costs in the test period. And so agreeing to some deferral of cost incremental to what was in that test period, subject to recovery at a later date. And then also clarifying that while in the initial direct testimony, there was, because the purchase price had not been allocated, there was a sense that there may be an acquisition adjustment there, and there did not end up being one.
So first of all, Ms. Lael, thank you for pronouncing Mr. Berzina's name because I was going to mispronounce it. So thank you for correcting that. I must confess, Ms. Lael, and I may have missed this during my review of the testimony provided here. Can you point me to where Mr. Berzina discusses Sleepy Hollow natural gas system assets as referenced in the settlement agreement?
I don't have the page number, but I certainly believe we could follow up and provide that.
I would ask that that be provided because I can't find it, but
Okay.
May have missed something. All right. Did you read well, just go ahead and ask it. Have you read the rebuttal testimony of Elaine Rich?
I am certain I read it at some point.
Which would be exhibit ER-4. Are you familiar with that?
If you want to put it in front of me, I'm happy to take a look at it, but there's a lot of testimony in this case, and I won't say that I have them all in my head.
So you're at exhibit EAR-4.
All 105 pages.
Great pages they are.
Yes.
Please turn to page 6, please.
I'm there.
Okay, thank you. Column AJ,
Yes.
you see that? All right, very good. You would agree with me that Ms. Rich is providing an update to Sleepy Hollow costs to 2022 actual, correct?
I believe that's correct. I assume this is the rebuttal filing that we're looking at here, and that was adjusting to actual costs. Yes.
Yes, very good. In row 53,
Yes.
okay. It states there are $0 in the natural gas utility rate base for Sleepy Hollow, correct?
In the update column, the revision, it's showing 0. I don't know that that means that there was 0 rate base dollars, because there would have been an original amount to that.
And that's my question, is the $0 the amount that the settlement contemplates to add to the rate base?
No, I believe it contemplates the rate base as likely directly filed, but the clarification is, where can you see that? And I'm not sure off the top of my head where that is.
Okay, well, we might want to address that with Ms. Rich at some point, perhaps.
Mr.
Okay.
President,
Yes,
if I might, as I'm flipping through this, I think on page 4, there is a column for Sleepy Hollow. I'm getting myself reoriented to these. It has been a while since I've looked at it, but page 4 of that exhibit, I think row 53 contains the rate base for Sleepy Hollow.
could you state what that is?
In column Q, that amount is 287,500.
Okay, thank you, Ms. Lael. Do you have Mr. Berzina's direct testimony? Front of you by any chance?
I might.
You turn to page 30 of that testimony. I believe it's in the direct. You there, page 30?
Yes, I am.
On page 30 of Mr. Berzina's direct testimony, he proposes to include $600,000 in the rate base, which would reflect the net book value and an outstanding balance of unpaid natural gas supply costs provided by Northwestern Energy, correct?
I believe that's correct.
Okay, based on that, is $600,000 the amount the settling parties are proposing to include?
I believe that's correct. And the reason it's half of that is you average rate base in the period. So beginning and ending rate base. So the 287, subject to Jeff Berzina actually mentioning that off the top of my head, I believe it would reflect an average of that period. So beginning and end of period, you take an average. I believe that would get you your 287,500, subject to the folks who know the details correcting me later on.
All right, very good. Do you know what the acquisition cost of Sleepy Hollow was?
I don't off the top of my head,
Okay, so the
other
answer,
than essentially, there was nothing paid in the transaction, but we did assume these debts. But again, Jeff Berzina would be the one to ask that too.
okay, thank you. We'll move under the over to the PCAM settlement provisions.
Okay.
Paragraph 15, which you've been asked a lot about, so page 6 of the settlement agreement. I would think you would agree with me, Ms. Lael, that there have been a number of questions posed today about this provision of the settlement agreement.
Indeed.
Indeed. You have answered some questions about the different filings that may be contemplated as a result of this paragraph if it's adopted by the commission, correct?
Yes.
So I'm just going to ask you directly, because I have some confusion in this area. How many different filings you believe Northwestern will potentially be submitting to the commission in accordance with paragraph 15? Can you list them?
I believe we will make one filing, and that one filing will encompass multiple parts. The multiple parts will include a prudence review of the asset, a reset to the PCAM base, pulling out what we believe the market purchases that are being replaced by the asset, including the operating costs, and then an adjustment to the property tax tracker base to reflect the property taxes expected for that asset. So in a nutshell, I think it's one filing with multiple components for the commission to review the facts and circumstances together, not separately.
So you were asked this question, but I'm not sure I understood the answer, or maybe I didn't hear it correctly. You contemplate this filing is going to be a different form of filing than your normal PCAM filing?
I think the normal PCAM filing, you would have the typical one we make on an annual basis that brings in the deferred unless the commission examine what costs have flowed through there. I think the PCAM base reset and a broader rate case filing, as we've done here today, looks at the broader PCAM base and updates that. I do believe this would look very similar to that PCAM base reset that you would see in this type of filing, and that would be coupled with the prudence review filing. So all together, similar to this docket, you've brought in an overall base revenue adjustment plus a PCAM base reset plus a property tax base reset, but it's all one inclusive docket. I would expect this to be one inclusive docket.
Okay, based on that answer, so would you anticipate that filing then would mirror a prudency review such? I'll ask you about each of these components of what normal prudency review would be, right? So do you anticipate that Northwestern Energy would anticipate that the filing would describe an RFP process?
No,
Would it include Northwestern supply portfolio?
I don't believe so.
Would it include specifics on plant operations,
Yes,
capacity needs?
no, not outside of what Yellowstone will bring. I think the prudency review would be limited to specifically that facility and its usefulness to customers. And so the broader issues that get taken up in an IRP process or RFP process, this would be specific to the Yellowstone asset. So certainly its capacity value of that specific asset, I would expect would be taken up in that case, but not the broader portfolio necessarily. But again, you're probably getting into questions that might be best laid for our supply team that puts those issues in front of you on a consistent basis, and they may answer in a different way than I am right now as to how that capacity calculation would be included in there.
I appreciate that. But what I think I'm hearing from you, Ms. Lael, is that the PCAM filing you're anticipating is not really the equivalent of a normal commission prudency review.
I think what this filing is meant to say is the commission would have the full opportunity to look at the costs that were to construct the Yellowstone facility, what that looks like in the sense of the adjustment to the PCAM base, which would of course give you some sense of the portfolio value there. Broader from that and some of the issues I think that come up in other dockets, I'm not sure that's contemplated.
Okay, so one filing, correct? That's what you
One
testified
filing,
to.
yeah.
Right, and you may have answered this already, but I'll ask it again. Does Northwestern Energy anticipate that filing would be submitted before Yellowstone County Generating Station is placed into service?
I would expect we would make that filing essentially concurrently or right at about the time that's placed into service. We would certainly be seeking to mitigate the amount of regulatory lag here and make a filing concurrently with that beginning to serve customers. And as we talked about earlier, likely would request interim rates for recovery of those operating costs, obviously subject to the commission adjudicating that docket.
I appreciate that. Thank you. So keeping along this line of questioning in paragraph 15, I may have missed this in my review of the settlement agreement, but can you point to me where in paragraph 15 of the settlement agreement it requires Northwestern Energy to make this type of filing?
It is a permissive filing, so we may make the filing. It is not required that we make the filing. The discussion amongst the parties was very clearly that depending upon rate review timing, all of these issues may get brought in a rate review as well. And so this allows us to make that filing out of course, but does not mean we have to.
Okay, thank you, Ms. Lael. All right, let's turn to paragraph 14 of the settlement agreement. I'm going to ask you some questions which were sort of touched on as part of MEIC's questions, but I do have some questions here. You're at paragraph 14, yes?
Yes,
You would agree with me that paragraph 14 states, quote, Northwestern shall file quarterly updates to the PCAM rates to adjust for any over or under collections to minimize the deferred balance, correct?
yes.
So under the settlement agreement's proposed quarterly updates that are contemplated, will Northwestern Energy calculate shared over under collections from the prior quarter and build into rates in the following upcoming quarter?
So the amount of deferred is always subject to the haircut. So the 10% sharing would have already been taken. So when we record the deferred balance, that is net of the sharing mechanism. And it would be the deferred balance then net of that that's rolling in for recovery beginning that following quarter.
So just to ask you more directly, so do I understand your testimony to mean that the 90-10 cost share will be factored into the quarterly
Yes,
adjustments?
to be clear, the deferred balance, whether it's quarterly or annually, is net of that sharing. We don't record, of course, a deferral for the amount that we're shareholders are encompassing. So that deferred balance is already recorded encompassing the sharing. The change here is the timing instead of on an annual basis. It's adjusted on a quarterly basis. It does not change in any way the math of what is in that deferred balance.
I must confess that I had to think about that question quite a bit as I was reading settlement agreement about how the mechanics of that would work with the year-end true up, if you will. So do you want to weigh into that a bit?
Certainly there's in the idea of the mechanism, there may be times where we are over or under. And so and we haven't been in this position in quite some time, years, because of the volatility of supply costs that we've seen. But if that deferred balance that we're capturing, to use easy math, say that's $10, and the next month that reduces, or the next quarter that reduces down, and say we were able to earn a bit of that back, then that balance would get adjusted with interest both ways back to customers. The key here is, and it's very similar to the, of course, the natural gas piece isn't subject to a haircut, but that rolls through on a monthly basis. The PCAM, the predecessor to that mechanism that we've talked about a bit here before, was a monthly adjustment to rates. And so this adjustment to rates would simply do that on a quarterly basis, but it would in no way change the way the deferred amount is determined.
All right, so asking this from a public interest perspective, whether there's adjustments quarterly or annually, is the ratepayer in any way benefited or harmed by either mechanism?
I would say the challenge that we've had in the pancake of rates that we have today certainly hasn't benefited customers. So what we rolled through on October 1st was not only interim rates, but costs that our balance sheet had been carrying for over a year for customers, and that price signal and the absence thereof. And certainly how that contributes to the FFO issues we have in our balance sheet, I don't think we're helpful to customers or to Northwestern. And seeing a more timely recovery of that, similar to what the natural gas mechanism does, I think is actually pretty important that customers see that benefit. And I would tell you on the natural gas side, it's analogous to customers will be seeing a significant decrease there quickly because natural gas rates broadly in the market have come down. And so that mechanism is very timely as to the customers at that time paying for the energy at that time. The way the mechanism, we incur costs, think about last July, the way then outside of the base, it will be next October when customers begin paying that if the mechanism stayed the same. And that could be a different set of customers and certainly no concurrent price signal with what was going on at the time. So my view is this aligns closer back to where mechanisms have been designed in the past. And then significantly, you can see it in operations on the gas side, how that works.
Certainly one of the concerns of the annual up, if you will, if you understand what I'm saying, is that you have large balances, correct?
Yes, the last year balance, I believe, my numbers might run together in my head, but over $50 million that rolled through then on October 1st, that had been essentially from that first dollar incurred 15 months earlier. And this year, I would tell you the first 6 months of that through December, we had a significant deferred balance. Again, we saw outsized market impacts both end of August, early September, and in December. And absent this change to the mechanism, again, you'd be at a significant delay for customers seeing that impact to them. And these are costs we don't control and certainly take a significant haircut, both in the 10% sharing, but then currently our balance sheet, when interest rates aren't cheap, having paid out those, typically those invoices come to us within 15 days and they're a 15 to 30 day payment. And then they sit there for sometimes over a year of recovery because of course, then it's a 12-month recovery of that. Changing to quarterly was pretty important to us in the sense of how we think about financial health, but also customers seeing the right signal at the time and then not pancaking those to where future events, I can't predict what may occur, but when you're still paying off the past, I don't think that's the best answer for customers.
Thank you. I'm going to take you back to paragraph 15.
Okay.
Talk a little bit about the cost reset. You're at paragraph 15.
Yes.
Right. So paragraph 15 states, quote, the stipulating parties agree that Northwestern may request a one-time PCAM base cost property tax base reset to be effective on the date of the Yellowstone generating station is placed into service. And I read that correctly.
Yes.
All right. Let's touch on the PCAM base cost reset. If Northwestern Energy submits a request to reset PCAM base costs, will all PCAM costs be reassessed, including forecasted marketed purchases?
This would be a full PCAM base reset. Yes.
Including forecasted market
Yes.
purchases. Okay, so dovetailing on the line of questioning that we've engaged in. So if Yellowstone, it's going to call it Yellowstone, if that's all right, is found to be prudent by the commission, will Northwestern still be requesting a PCAM base cost reset?
The method for Northwestern to recover the operating costs. So that the context of this conversation was significant and material operating costs that Northwestern begins to incur as soon as you flip the switch and it's serving customers, and the inability from an earnings perspective to simply absorb that. And so the settling parties work together on what is a path to recover those if we aren't going to do the more broad rider, which provides capital and operating costs. What is a path here? So this is the narrower path. And your question was, would that include a PCAM base reset? Yes, because Yellowstone certainly contributes to taking a piece of that market exposure we have today, reducing that and providing that reliability to customers. The key piece there is we need some degree of recovery the operating costs at that time. The asset will be serving customers. We think that's reasonable. The settling parties pushed back and said, I think if we want to do something that's holistic, the commission should see a prudence review at that same time. So that's when I say it's one encompassing filing that allows you to look at the asset, look at the ultimate cost of the asset, look at the impact to the PCAM, and of course, reset property taxes. The one hand goes with the other. That was the point of putting this all together in one filing.
Okay, back to paragraph 15. FERC account 547 dealing with fuel,
Yes,
estimated to be 8.4 million annually, correct?
yes,
But that's after Yellowstone is placed into service.
yes.
Let's talk about cost adjustments to Yellowstone. Actually, I'll wait for the case sheet. Right, paragraph 15. Reads this modification of the PCAM to allow for operating and maintenance cost recovery related to YCGS will be limited to time period between the date the plant is placed in service and the implementation of new rates following Northwestern's rate review. Did I read that correct?
Yes,
Okay, and then looking at the bulleted expenses listed in this paragraph,
yes.
those, as I think I heard you testify to earlier, those are typically not covered through the PCAM.
I think there's certain accounts that are typically not in the PCAM. That's correct.
Would you walk through each of these bullet points then and tell me which ones would normally be included in the PCAM?
I do not have the PCAM tariff off the top of my head, but I believe the reason we bullet pointed these is because they aren't ones that are typically in the PCAM. I can walk through these and give you a flavor for what they are, which of course, variable non-fuel O&M is the rest of what it takes to run the plant. So those will go up and down with the frequency with which it's dispatched. And to not get into my colleagues who know this much more, but on an economic dispatch, inherently, if it's running, it's providing a lot of value to customers. And so the non-fuel O&M, think about things like ammonia, literally the stuff that goes into the facility to run it. That's your first bullet point, which is in FERC account maintenance of generating an electric plant. The variable engine maintenance expenses, no surprise, the more you run engines or the less you run engines, the more maintenance they take. And that's included, meant to encompass those costs in FERC account 553. And then the fixed O&M costs of approximately, or estimated to be 2.7 million on an annual basis, are included in FERC account operating, supervision and engineering, and miscellaneous other power. Again, this is the cost of literally having the folks at the plant to run it once it's in service for customers.
If we were to adopt paragraph 15 of the settlement, then we would be authorizing these expenses to be temporarily recovered through the PCAM, correct?
I believe if you adopt paragraph 15, we are agreeing we will come in for a filing and that you will review those costs at that time. And what we're asking for and trying to be very clear on is what we will ask for as a path to recover the operating costs, and some of which aren't typically in the PCAM, as a bridge to the ultimate recovery and base rates of that facility. I won't opine on what it does or does not, depending upon the final order, commit you to.
Okay, you referenced that it would be a bridge, correct?
Yes.
How long is that bridge?
This is the part of my very candid comment is I don't think it'll be very long. Our costs have materially continued to go up. While we have a known and measurable period in this rate case, it in no way encompasses the amount of increase in operating costs that we saw in 22 alone. And inflation is not transitory. I think we can all say that sitting here today. And when this plant is expected to be in service in early 2024, and given the amount we are currently investing in infrastructure in excess of our rate base, I do not expect it will be a lengthy amount of time until we're in for a broader rate review again.
You're not committing Northwestern Energy today to have those expenses carried through or recovered until the time of the next general electric rate case.
That's what this is saying, is it provides that bridge. We haven't committed to is specifically when that next filing is. The key piece here, of course, is it does not include capital. It only includes operating costs.
Okay, let's turn to page 5 of the settlement, please. Paragraph 14, jumping around here a bit.
I'm there.
Okay. You would agree with me that paragraph 14 states that for future PCAM filings, interest will be applied to the deferred balances as proposed in your testimony, correct?
As proposed in Ms. Fang's testimony.
My question then is, should interest be applied symmetrically to both negative and positive deferred balances under the PCAM?
I believe if you, subject to Ms. Fang's testimony, it indicates that, yes, that interest application would be symmetrical to both either an over collection or an under collection.
Is that consistent with the settlement agreement terms?
Yes.
How so?
It says interest shall be applied to the deferred balance as proposed in Ms. Fang's testimony, in the sense of trying to not keep this wordy and restate what is in her testimony. Her testimony indeed indicates that our proposal is that interest works both ways.
Okay, thank you, Ms. Lael. All right, let's move to, I'm sorry, Mr. Hamilton, do you have questions?
Thank you, Mr. President. Just a point of clarification. Ms. Lael, I understand that under the PCAM base adjustment discussed in paragraph 15, that you would not be seeking recovery of capital costs. Is it still true that Northwestern would present information about the capital costs of the plant?
That is correct. In order for this commission to have a prudence review, we would expect to present information on the capital, but the actual adjustment to rates for that capital would be deferred until the full rate review.
All right, thank you. Nothing further.
All right, thank you, Mr. Hamilton. Recross, Mr. Nell. All right, go ahead.
Well, in response to a question from President Brown regarding capacity needs, I thought I heard you say that the evaluation of the prudency of the capacity needs for the acquisition of this plant would be evaluated by looking at the Yellowstone gas plant in a standalone light and without regard to the entirety of what's happening in a larger lens. Is that right? Is that what you said?
If I
apologize. A larger lens or landscape. And I just wanted some clarification about your testimony regarding what you would be looking at for capacity needs and the evaluation of this plant.
That's a good clarification, and I would maybe restate what I ineloquently stated in that regard is the exchange we just had, which is the commission would have an opportunity to fully look at the capital, although we wouldn't receive rate recovery at that time, but a full review of the capital is the key piece of that. The capacity determination and how that contributes to the overall portfolio, I would certainly say is not within my scope of testimony or understanding. And we do have other witnesses that can speak to that very specifically. And I would suggest we defer that question to them.
You were asked a number of questions about timing. Is the plant still continuing to get built today, as we sit here today?
I think as most in this room are aware, there was the construction air permit was vacated last week. And so there is currently a pause in construction.
Previously, it was my understanding that there was sort of a January 2024 online date. Has that changed?
I think we've said early 2024. I couldn't tell you sitting here today, of course, with the current situation when that in-service date would be projected to be.
Is there someone else who could?
Likely Mr. Hines would speak to that, but again, it's a fluid situation.
Thank you. Thank you, Mr. President.
All right, thank you, Mr. Nell. Mr. Grom.
Thank you. Thank you, Mr. President. Just a couple questions. I was confused by your conversation with President Brown about what the prudency review contemplated by paragraph 15 for Yellowstone would entail. Can you more precisely describe, or as precisely as you can describe, what you envision will be addressed in a prudency review, in the prudency review that you'll be filing when you make this PCAM filing?
I can take a stab at it. And
right.
boy, we thought paragraph 15 was wrote very clearly. And I think after today, I would say it's probably not, but my stab at it would be this. It's an all-encompassing filing. And my comments on how PCAM goes with a prudence review is that asset is being brought and being built to provide customers that service, and instead of relying upon the market for those services. So the prudence review would look at the actual cost to construct that facility, and then the balance of that cost and the capital with the impact on PCAM, which was the thrust of the settling parties, and you can ask them about this, but wanting to see the impact of, now we have this capacity that we'll be using and dispatching for customers. What impact does that have to adjust the PCAM base? There was questions around how that would overall look. So it's an all encompassing. So when I think of prudence, it's the ability for the commission to examine, just like they examine all the other rate base that comes in this case, you get to see the details of those assets and what the cost of service is related to them. So of course, the operating cost of that, and examine the support for that. We have to put that case forward. That would be what the commission is taking a look at. And then in tandem with the PCAM base adjustment, what's the impact to the expected market purchases from that asset?
Right. I get all that and agree with all that. I guess when I think of prudency, however, it is what you said. It's also whether or not, and it's here in paragraph 15, the plan is in the public interest. And in part, and I'd say significant part, that determination would need to be made by looking at, for example, what are alternatives to that plant? Is that plant needed? Is that plant the most prudent way for Northwestern to be expending customer dollars in order to meet whatever need was identified as which that plant was going to fulfill? So do you have a different view? It seems to me that your characterization of what a prudency review will entail is different than what I just postulated.
I think that various interveners in this room probably have a different take on the prudency and your public interest comments, and understanding that there's a variety of viewpoints here. The clarity, I would say, is nothing in that docket will preclude any parties from raising any concerns. So if your viewpoint is that plant is not in the public interest for a variety of other reasons, it'll be an open docket for any intervener to raise those issues in that case.
Right. I was, okay, and I appreciate that. Again, I was just trying to understand what, and try to get some precision on what you thought this prudency review would entail, but I think we can move on. One further question on the about resetting the PCAM base. I just want to clarify this. So when you make this filing, you will come in and include not just, or seek to include, not just those gas transmission reservation costs and these O&M costs, but the filing you will make will seek an entire reset of the PCAM base. So it will be up to date, modeling, market, costs, et cetera, et cetera, et cetera. Is that correct?
Yeah, I believe it contemplates a full PCAM base reset.
Okay, thanks. Thank you very much. No further questions.
All right, Mr. Uda.
Questions?
I don't know if anybody heard that, but it was no questions. Barbara, do you have questions?
I do, yeah. Just one question, clarification question, Ms. Lael. I believe you testified that the gas plant will replace market purchases. Is that correct?
Yes.
And so which market purchases will the gas plant replace?
So again, anytime a resource comes into the owned portfolio, that should decrease ultimately the amount of purchases we're on the market for to serve customers. Now, the piece at that time that I can't predict is what is load predictions, what's the customer count, all those sorts of things. But the asset Yellowstone is meant to provide rate-based owned resources to get us toward resource adequacy. And that certainly would have an expectation that that reduces the amount of market purchases. The piece I can't speak to is obviously think about a year and a half from now, what our load profile looks like and how much of it it'll replace.
Okay, so you can't right now say like how much in terms of dollars?
No, certainly. And that would depend upon some of this conversation around pricing at the time. And that I certainly can't predict.
And how about how much in terms of megawatts?
I think there's a stated megawatt of the facility. And again, there's, even though Yellowstone is not in this docket for cost or any of those things, it's meant to be a facility that provides critical reliability on our system. And I think, as we all know, we firm a significant amount of variable generation resources. So it's megawatts available to provide service.
And can you identify the number of megawatts? And
Off the top of my head, I knew you were going to ask me that, and I was having a brain block as to the Yellowstone stated megawatt. So subject to check, someone else will have to give it to me. I think it's 270.
Ms. Hine, do you want to,
Yes, thank
you
you.
want
I
to
believe
board
it's
there, your witness?
175.
you want to, would
One say, okay, thank you.
you like to ask her that question?
Does it sound correct to you, Ms. Lael, that the nameplate output of Yellowstone is in the range of 175 megawatts?
Thank you, Ms. Heim, for correcting my brain block today. I believe 175 sounds correct.
Ms. Chilcott,
okay, thanks. That's all I have.
thank you. May I see Ms. Harmon? All right. Redirect, Ms. Hine?
I do have some. I'm mindful that we're in the last hour of the day and people are getting
We are powering through. You are all on notice.
Okay, then let's go. So I'm going to go in order of the cross-examining cross-examination questions that were asked. When you were talking to Mr. McGraw initially, he had suggested, he had asked you a question posing an all-in bill impact, including the flow-through costs. In evaluating the impact of the settlement, is it fair to look at the flow-through costs in PCAM and property tax as part of the settlement increase?
I would separate the matters, and the reason I would settle or separate them is I think about it in the sense of the base revenues are where we earn a return, and the PCAM market supply costs and property taxes are things that are outside of our control and are mechanisms that are adjusted in this rate review. But the settlement really refers to the give and take on the base rate amount. But certainly Mr. McGraw's point of total impact to customers, these are very complex issues. And I'm certain that when customers see their bill, they don't overthink the amount it went up and what pieces we do or don't make money on it. They just see the total. So I think that's a fair clarification.
So I would direct your attention to paragraph 21. You received some questions, I believe, from Ms. Harbine about what issues were not in the settlement. Can you reflect on what paragraph 21 was intended to accomplish?
Paragraph 21 specifically states that this does not resolve issues related to our request for deferred accounting for the acquisition of small natural gas production assets. And this was meant to line out the one kind of significant item that we could not reach agreement upon.
So I apologize a little bit. I feel like I'm skipping around, but I'm just going in order. In paragraph 15, it was referred to as an incomplete solution. And there was some confusion around whether or not that review is mandatory, whether or not Northwestern is agreeing to come in for that PCAM base reset. Can you just clarify for the record whether or not, in your view, that PCAM based the entire package, the PCAM based reset, the property tax tracker update, and the prudency review, if those are mandatory?
Certainly, and for maybe some clarity of what has been a difficult paragraph, I do believe it, or I interpret it as one package together, and it is not mandatory, it is permissive. So the conversation we've had around timing a rate review, those things may impact whether or not we come in for this filing separately, or whether it would come in a general rate review.
So let's talk, staying in paragraph 15, let's talk a little bit about the prudency process. If the commission requires a prudency process similar to what would be adjudicated in, for example, a pre-approval docket, would Northwestern comply with that?
I think that's a reasonable interpretation of what we were thinking about in this docket.
And would you expect Blue LaFave to speak to prudency filing in the context of that?
I think this commission has had Blue LaFave in front of them a lot, and I certainly would expect that he would be involved in that filing.
Staying in paragraph 15, in regards to the rate review timing, what's the harm to Northwestern to carry Yellowstone County Generating Station capital on the books? And how does that function as an incentive to file a general rate review?
I think and maybe where I was confusing my numbers earlier, my 270 cost of the plant versus the 175 a megawatts, that's significant rate base and it's significant investment on our part. So the questions with regard to timing of when we might be in for a rate review, I would certainly suggest that that's material to us. And we would be looking to minimize that regulatory lag, as we've talked about a lot. This doesn't provide for recovery of that capital. And so we would be looking to do so on a timely basis, recognizing we haven't committed to a specific filing timeline here, but I think everyone can get a sense of the materiality of that number to us.
When you were discussing interim rates from paragraph 15, I just want to make sure we're all on the same page. Can you clarify whether the interim rates would be effective before the plant goes into service?
No.
Could Northwestern use the paragraph 15 mechanism of the PCAM base, this entire package, for any other generation asset other than Yellowstone under the parameters of the settlement agreement?
No, a significant compromise amongst the parties is we had proposed a broad reliability rider. And what this does is narrow this to Yellowstone only, and only the operating costs related to Yellowstone.
That's all I have.
Thank you, Ms. Heim. Do you request this witness be temporarily excused?
Yes, sir, I do. Thank you.
All right, Ms. Lael, you are temporarily excused. All right, Ms. Heim, do you have any further witnesses to support the settlement agreement at this time?
At this time, I don't. We reserve the right. We will call, let me revise. We will call Cindy Fang tomorrow. I do believe FEA has its witness available to be called now if you'd like to entertain another witness today.
I would like to entertain another witness today, so I will ask Captain if he would like to put his witness on. Right, this is Mr. Meyer.
Yes.
Good afternoon, Mr. Meyer. Thank you for participating today. You didn't happen to be sworn in when we did the swearing in mass, did you?
I was. I jumped on and got sworn in then.
Okay, Captain, you may proceed.
Mr. Meyer, can you hear me?
Yes, I can.
Please state and spell your name for the record.
Sure. My name is Greg Meyer, Gregmeyer.
And by whom are you employed in what capacity?
I'm employed by Brubaker and Associates, Inc., 16690 Swingley Ridge Road, Chesterfield, Missouri, 63017, and I'm a principal with the firm.
Did you file direct testimony in this case on behalf of federal executive agencies?
Yeah, I did with other members of the BAI staff. And could you speak up just a little bit, Mr.?
Sorry, Mr. Meyer, can you hear me now?
There you go. Yeah, that's better.
Yeah, I've been having trouble with the microphones today. All right, can you please list the other members of the BA staff who filed direct testimony on behalf of FEA and the issues they addressed?
Sure. Christopher Walters filed on, excuse me, return on equity. Brian Andrews filed direct testimony on behalf of Northwestern's depreciation expense. And Brian Collins filed direct testimony on addressing class cost of service and revenue allocation. And then I filed on various revenue requirement, the labor adjustment and many of the riders that were proposed for by Northwestern.
Have you reviewed the settlement agreement reached by certain parties to this, in this case, that's been admitted as Exhibit Joint 1?
Yes, I have.
Does the settlement agreement address return on equity?
Yes, it does. It's it establishes a 9.65% return on equity, which is, I believe, consistent with what is currently included in base rates.
Does the settlement agreement address the depreciation?
Yes, it also does. The settling agreement reduces depreciation expense by approximately 3.97 million over what Northwestern had filed, and that's in the settlement agreement as well.
Did the settlement agreement address the riders that Northwestern requested?
Yes, it does. The reliability rider has been testified or discussed a lot today, was rejected, and in its place, Northwestern is allowed to is permitted to file in the PCAM for the operations and maintenance expenses associated with Yellowstone Generating Station when it becomes online. The business technology rider was rejected and is not being implemented. The enhanced wildfire mitigation plan, the parties agreed, and the settlement reflects that Northwestern can track those costs subject to certain caps that are established, I believe, in Exhibit E. The fixed cost recovery mechanism was not implemented. At the PCAM, there's certain changes in the PCAM quarterly reviews and interest applied to the deferred balance. I believe that's all. Oh, and there was I'm sorry, excuse me, there was a demand side management agreement in the settlement agreement also.
Now, turning your attention to the class revenue allocation contained in the settlement agreement, specifically the revenue allocation to GS2 transportation class, do you support the revenue allocation?
Yes, we do. Both Northwestern and the large industrial group filed class cost of service studies that reflected that the GS2 transportation class should actually have a rate decrease. And in the settlement, a 0% increase is assigned to those classes, which we find to be reasonable.
Mr. Myers is available for cross-examination and questions from the Commission Council or Commissioners.
All right, thank you, Captain. We'll do the same order of cross. So Ms. Brunel.
Thank you, Mr. Meyer. I'm Monica Trinnell. I'm just standing up. I don't know where you're looking, where the camera is.
I can see you.
Okay, thank you. Just a couple of questions, Mr. Meyer. When did you first approach Northwestern? Did they approach you about the settlement?
I don't know the specific timeline when the FEA was approached. I was requested to attend certain settlement negotiations by Mr. Duffy.
Okay. Is my microphone on? Okay, thank you. Mr. Meyer, in your direct testimony, and just, I guess, for context and clarification, in general, the federal executive agencies that you,
Objection. So, just as he's only testifying to settlement today, he will come back again and testify to his direct testimony. So I don't know if this question is going to be clearly towards the settlement or to the direct testimony.
I was going to the settlement. I wanted to set the stage of who is served by Northwestern, and I think I was just going to map the Air Force Base in Great Falls, just to set the stage in the context here.
All right. Please proceed.
Thank you.
Overruled.
Thanks. Mr. Meyer, do you know what the annual use of the Air Force Base is?
I don't have those figures available, but I believe Mr. Collins would have looked at that in the context of his review. It wasn't part of my review.
Okay, thank you, Mr. Meyer. The question that I want and the information I'd like to have the commission have in front of it as it assesses the settlement is the difference between the dollar amount that you would have paid under the initial application and what you will pay under the settlement. Do you have that number? Or does
No, I
anybody?
just know that as a result of the settlement that we have no rate increases for Malmstrom Air Force Base. The other FEA offices and facilities will see rate increases.
And do you know when you say that other agencies will have rate increases, do you know relatively what the amounts are for those other ones vis-a-vis Malmstrom?
No, I do not.
Okay. And I want to ask you, what was your position in this settlement? Did you hear the discussion throughout the day and the questions of Ms. Lael throughout the day?
I was on for most of the time. I had to drop off a couple times for other client calls.
Okay. Did you hear the discussions about the provisions in the settlement agreement regarding Sleepy Hollow?
I heard those, but we only, the FEA only concentrated on the electric case, and it's my understanding that Sleepy Hollow was a gas issue.
Okay, very good. On the electric side, and I don't want to mischaracterize it, but what I understood kind of as we were working through paragraph 15 and the impact of that in the effort to recover the gas plant costs through the PCAM, it is, and this is my characterization of it, what they have essentially done in the settlement agreement is created a little mini rider within the settlement that is going to allow the cost of the gas plant to come into rate base. And in your testimony, you were opposed to riders. So can you tell us how you got comfortable with having this gas plant in rates, given your opposition to riders and special regulatory mechanisms?
Well, I am not a fan of riders or trackers. However, in this issue, it became clear to me that the reliability rider was mainly being proposed for the recovery of Yellowstone County Generating Station. And in lieu of that, I filed direct testimony that said that using a rider to recover a generating plant wasn't a proper rate-making mechanism, in my opinion. So I had proposed a accounting policy called construction accounting, which allows the utility to defer the revenue requirement associated with that generating facility for some time until it can file a rate case. Now, in order to qualify for construction accounting, the utility must demonstrate that they could not have filed a timely case to recover those costs within a base rate case. In the settlement agreement, the parties agreed that that basically the PCAM could be used to only collect the O&M costs associated with running that facility. And so given that versus the positions that I had proposed in my direct, I found that to be a reasonable alternative. Now, I only take issue with one thing you said. The total cost of operating Yellowstone Generating Station is not in the PCAM, and it will never be in the PCAM because the parties have agreed that the capital costs and the recovery of those capital costs will be delayed until the next rate case. So the PCAM is not there to make Northwestern whole on the total operating costs of Yellowstone Generating when it becomes operational.
Thank you, Mr. Meyer. Will you agree with me that what you have proposed here in paragraph 15 is not typical or historically contemplated by what the PCAM exists to do?
I have not researched the PCAM. It came up in part of the discussions or the settlements as a mechanism, and that was fine with me because of what I looked at as the limited recovery of those costs for operating Yellowstone.
Thank you. One last question. If paragraph 15 were removed from the stipulation, would you still sign it?
I don't believe we can, given the clause at the back of the stipulation that says it's a total package.
Thank you, Mr. Meyer. Thank you, Mr. President.
Thank you, Mr. Nell. Mr. McGraw,
No questions.
Mr. Huda.
No questions.
Mr. Huda, is your mic still live? Ms. Chilcott,
No questions, Mr. President.
Sarbanes?
No questions.
Very good. This would be the time and place for commissioner questions. Vice President Fielder, she waves off. Commissioner O'Donnell? You still with us, Commissioner O'Donnell? Seeing not. Commissioner Bukacek? All right, I have no questions for this witness. So we are on. So there is no opportunity for recross. So Captain, your witness, do you want to redirect?
No redirects.
Okay, do you want to temporarily excuse this witness?
Yes.
All right, thank you, Mr. Meyer. You are
Thank you.
temporarily excused. Thank you for participating today.
Sure, thank you.
All right, next settlement sponsoring witness.
Can we take a 5-minute break to confer with the settling parties to see what witness we might have available?
This time I will give you 6 minutes.
Thank you.
All right, the time is now 4:24 p.m. We will go off the record and return at 4:30. Well, we're gonna. All right, the time is now 4:32 PM. We are going to come off the record. Or we're going to come back on the record. Thank you. Off, we're going to come out on the record. Ms. Heim, did you have something?
I do.
Offer at this
So
point.
we're in a little bit of an odd spot. We're ahead of schedule. And so the next witnesses we had thought to call are not available. What we could do, the bill impacts are ready and we have copies for everybody. We could call Cindy and have her walk through those so that then everybody has an overview of them to study overnight.
How long do you anticipate Ms. Fang's testimony would be?
It would be less than 30.
Okay, is there any objection to that? Ms. Harmon?
Can I just ask a clarifying question? Are you intending to call Ms. Fang this evening just to speak to the customer bill impacts analysis or more broadly to any questions about the exhibits or other deferred questions?
I prefer to keep it just to bill impacts since we have such a short amount of time. And then we'll call her again tomorrow.
Ms. Harmon, are you all right with that? So the idea would to bring Ms. Fang on just to testify to a discrete issue. Is there any objection to that? Seeing none. All right, Ms. Heim, please call your witness.
Northwestern calls Cynthia Fang to the stand.
All right, Ms. Fang, I believe you were in the room when we did the swearing in mass, correct? All right, your witness.
Thank you. And I believe we are going to hand out exhibits while we do the preliminaries. Ms. Fang, can you please state your name and business address for the record?
Cynthia Fang, business address is 208 North Montana Avenue, Helena, Montana, 59601.
And by whom are you employed?
Northwestern Energy,
And what is your title?
Vice President, Regulatory Affairs.
Did you participate in the negotiation of the settlement currently marked as Exhibit Joint 1?
I did.
Can you identify what is currently being handed out?
What is being handed out are two exhibits. One that looks like this with the grids. This is going to be the electric bill impacts that compare current rates to the final settlement rates. And then the other one without the grids, these are the natural gas bill impacts comparing current rates to the proposed settlement rates.
Okay, so let's look at the first document with the grids. I believe that document.
Hold on 1 second.
Pause, I'm sorry.
Lisa, did you get a copy of this? All right, does every party have a copy of the two documents at this point in time? Please let me know verbally whether you do not at this point in time. Okay, Ms. Fang, I would ask you to be more detailed in your description of the documents for purposes of the record, first of all, but second for my own ability to track your testimony. So maybe you could label the documents or
I can take
describe
her.
the documents. Okay. All right, please do.
Okay, Ms. Fang, can you look at the electric utility services bill impact document? You see what I'm?
Yes.
Okay. So can you describe what it looks like, but read the top text on lines 7 and 8?
So on the front page, you'll see Northwestern Energy in the corner, and then below that, residential electric utility service bill impact analysis. The first page is for residential.
Just pause. We have to mark it for the record. So I believe that document has been marked North NWE 48. Is that correct?
My version, yes.
So we'll move it in a minute, but I just want to make sure. All right, can you please describe what is NWE 48?
So NWE 48 compares the bill impacts for different customer groups, comparing March 1, 2023 current rates that you should see as the header in column D on the front page. And then in column G, you should see final settlement proposed rates. What this does is compares the bill impacts that customers would expect to see in the event the commission were to approve our settlements, the settlement that's before them. So with that, the first page reflects residential bill impacts associated with a typical residential customer using 750 kilowatt hours. And so what's captured in the current rates customers are paying today is the implementation of our interim rates that occurred on October 1st, as well as the implementation of property taxes on January 1st, among other items. And so with that, if you follow down column J on line 27, you'll see the total bill impact of $8.24, which is a bill impact of 7.6%. And then below that, you'll see a small table that shows the bill impact associated with different levels of residential usage. Now, if we continue to the second page, on the second page, you should have the bill impact analysis for a GS1 secondary non-demand customer. On the third page, you should see
Actually, I'm sorry, Ms. Fang, I'm going to stop you. Can you please identify what is a GS1 secondary non-demand customer?
So what we have here is a GS1 secondary non-demand customer. This is the bill impact reflects a customer with total usage of 3,500 kilowatt hours on a monthly basis.
Okay. And can you provide the breakdown of what the projected bill impact is?
So for this customer, the projected bill impact is for that 3,500 kilowatt hour customer would be $17.60, which is a 3.3% bill increase.
Can you identify the next page, please?
So on the next page, this is a GS1 secondary demand customer. They're with a typical usage of 3,500 kilowatt hours per month and a demand of 12 kW. The bill impact expected for this customer is $21.47, which is an impact of $4.36%.
Okay, and the last, oh, no, I'm sorry, the next page in this document.
The next page is for a GS1 primary non-demand customer. This is a customer where for the typical usage is 2,000 kilowatt hours per month. This customer would expect to see a bill decrease of $5.54, which is a decrease of 2.24%.
Okay, and the next page?
The next page is for a GS1 primary demand customer with a monthly usage of 200,000 kilowatt hours and 400 kW in demand. That customer would expect to see a bill decrease of $173.95, or a bill decrease of basically 0.77%.
Okay, and the next page?
On the next page, we have a GS2 substation customer with a monthly usage of 650,000 kilowatt hours and 100 kW in demand. That customer would expect to see a bill increase of $2,442.72, or a bill increase of 4.41%.
Okay, and the next page?
The next page is a GS2 transmission customer with a monthly usage of 650,000 kilowatt hours and 100 kW in demand. That customer would expect to see a bill increase of $1,489.61, or 2.69%.
The next page?
On the next page, we have a irrigation non-demand customer with a monthly usage of 1,342 kilowatt hours. And that customer would see an expected total bill increase of $5.02, or a bill impact of 2.62%.
Okay, and the last page in this exhibit?
This is an irrigation demand customer with a monthly usage of 12,260 kilowatt hours and a demand of 41 kW, with a total bill impact of $114.24, or a bill impact of 7.22%.
At this time, Mr. Chairman, Northwestern would move the admission of NWE 48.
Is there an objection? Ms. Trinnell.
Thank you, Mr. President. I do want to register an objection. It's 4:45 PM after a full day of the hearing. All of the information in this exhibit has been available to the company for well over a week. There is no excuse for why we haven't had this along with the settlement. We're being blindsided and being expected to, and the commission is too. I object to the settlement. We object to this exhibit, and we object on due process grounds. Thank you.
Ms. Heim?
Well, we can lay additional foundation at how much people have been working over the last week trying to generate the detail of this document. I think that the bill impacts are what the interveners have been asking us for, and so it's appropriate.
Does anybody else want to be heard on this matter? Sarban?
Another clarifying question. Is the intent that the interveners are to cross Ms. Fang on the bill impact analysis this evening, or was the intent that it's deferred till tomorrow morning?
I would absolutely expect that to be deferred until tomorrow. Of course, it's in the Purview of the chair.
Yes, it is. Anyone else want to be heard on this? Yes.
Could we request that,
Can you identify yourself?
yes, sorry, Melissa Hornbein for Renewable Northwest. Could we request that these documents be circulated to the parties via email this evening? Thank you.
Northwestern will absolutely do that.
Very good.
And while we're making requests, if it's possible to provide additional exhibits with the bill impacts from the pre-filing rates, assuming that information is available, we'd like to see that as well.
That's fine.
I don't know that that is available. If it is, we'll circulate it, but I'm not sure that that calculation is.
Is that satisfactory?
Yeah, I guess I would assume it's available and was the basis for Ms. Lael's testimony earlier today that the residential bill impact from current rates was around $8 as reflected in NWE 48 from current rates and around $11 from pre-filing rates. So whatever the basis for that is, we'd like to see it.
That's fine. Is that possible?
As soon as it's available, we'll circulate it.
Excuse
Yes,
me,
Chuck.
Thank you, Mr. President Brown. I suspect Northwestern is aware of this, but a similar bill impact analysis was prepared and is included in the initial application. I'm not quite sure whose testimony it's in. It could be Mr. Durkin's, but I know that there was an impact rate analysis similar to this using rates that were set in 2018 as the initial base, and then comparing the proposal to those 2018 rates. So it's there. I'm not sure how long it will take to assemble it all and compare it to, what they're proposing in the settlement, but it is available.
Can we inquire of our witness?
Sure, if you would like to. So I'm going to reserve my ruling on Ms. Trinnell's objection. Would you like to order your witness?
I would, thank you. Ms. Fang, can you respond to the questions related to the true up of rates from the beginning of the rate review?
So it is correct that we did file with our direct testimony what rates were at the time of that initial filing. So one of the exhibits within Andy Durkin's testimony, subject to check, I do believe it's ADD 13 is what I think it is as far as the exhibit that has that starting point bill impact. And so when comparing the information that's in these exhibits, that would be the place to look at as far as how it compares to rates that were or bills that were current at the time of the initial filing of this rate case.
Is it fair to say that Northwestern hasn't put together that analysis or done that math in a way that we can circulate it this evening?
At this moment, no, and I think it depends on what time you define evening.
Vice President Fielder?
Thank you, Mr. President. Just for clarification, I want to be sure that the exhibit that we have before us is NWE 48 is monthly electric bill impact rates under the settlement agreement. Is that correct?
Correct.
Okay, thank you.
Carmen?
I would renew and clarify my request. If the information is available, it should be easy to plug in. I realize it would require evening work, but plug in as an additional column so that we have in one place the actual customer bill impact resulting from the proposed settlement based on pre-filing customer bills.
It's fine.
I guess my struggle is promising work that I know I am not the one who is. I don't know how heavy that lift is, and we don't want to promise something we can't do.
All right, anybody else want to be heard on this?
I believe maybe the witness would like to be.
Hey, would you like to continue witnessing? I'm still holding the objection in abeyance at this point in time.
Ms. Fang, do you have additional testimony on when or how we might provide the additional data?
If the request is to provide a comparison of, so what I read off is the total bill amount for the typical customer within each of those schedules. If the request is to add what was current at the time of direct filing to that picture, that can be done as far as this evening. The bigger challenge would be the tables that capture the range of usage. So if it's just that one customer bill, that can be completed this evening.
Okay, anyone else? Okay, well, here's my ruling on this. I am going to hold Ms. Trinnell's objection in abeyance. I am not going to admit this exhibit Northwest Energy 48 at this time. What I think we'll do is to see how far we get this evening, and when we circle back tomorrow, we can revisit this topic. I do, however, believe that each of the parties now has a copy of this document and should use this evening to talk to their expert witnesses about it so that they are prepared to cross-examine the witness about this document tomorrow, should it be admitted. So you do have notice now of this document. Ms. Heim.
Could we also mark the other document, which is NWE 49, the natural gas bill impact analysis? Just so
Yes, we can
oh,
mark it.
Yeah, exactly. I won't move it, I promise.
All right, so that's NWE 49.
49.
Okay. You have any more questions for this witness at this time?
I do not. I think it's better to reconvene.
Okay. All right, council, parties, members of the public, commissioners. Time is now 4. You want to weigh in 5 minutes before? Yes, I was going to go through that. Yes, go ahead.
Thank you, Jason. For the commission and the party's information. First, tomorrow the LCG does intend to call, as was discussed, both Mr. Higgins and Mr. Bieber. I wanted to note, however, that unlike witnesses so far, the LCG's intention is to call those 2 witnesses for purposes of all of their testimony, not just the testimony and the stipulations, so that they don't have to come back to Helena, because they're both appearing here live and in person. So I just want to let everybody know for your preparation tonight that that's our intention, is to have them address all of their testimony in the morning tomorrow. And then secondly, I've circulated earlier today to the parties and to the commissioners what has been identified as LCG Exhibit 5. That's an exhibit that we intend to discuss with Mr. Bieber on the stand, but that has been circulated to everybody. But I just wanted to also let everybody know that that's going to be coming up tomorrow morning as well. Thank you.
Tarline.
Not winning any popularity contest, but I did want to clarify, we moved MEIC 3 into the record, and that's been admitted. There's a little hiccup in that, and Ms. Norcutt and I discussed, there were actually 2 emails, and not all of the attachments are appropriate for submission. So we will address that this evening, and I will get a new version of MEIC 3 that includes the full email thread that was admitted tomorrow, I believe, or this evening.
All right, Ms. Harbine, I am putting the responsibility on you to revisit this topic in the morning and give us an update of where we're at on that. Other matters?
Yeah, excuse me, right here. I would just want to mention, we want to do the same thing with our witnesses as Thor's doing, have them call tomorrow and ask all questions and be able to excuse them after that.
Right. Noted.
Could we temporarily excuse her?
You may. Ms. Fang, you are temporarily excused. Yes, Mr. Trennell.
Housekeeping question.
Yes.
And in terms of the exhibits that were offered and refused, will they be in the record for purposes of any review?
I'm not sure, Mr. Trennell, I'm not sure
So exhibit 350 Montana 24, we had offered and it was refused. You know, I'm happy to sort of sit on this and see if we can revisit it and maybe get it in. But I definitely want it in the record for purposes of review. So as an offered and rejected exhibit, I just want to make sure what's sitting up here on the easel as 350-24 is an exhibit that we would like to be in the hearing record.
Mr. Trennell, this is the first time I've ever encountered this in legal practice, so congratulations. I have conferred with our counsel. I think the way that we will handle this is obviously this is not an evidence at this point in time. We will keep it as part of the hearing record in this matter for purposes of appeal. Additional housekeeping matters. Lord.
If the intent is to make the demonstrative on the easel part of the administrative record for purposes of appeal, which is all fine with me, we just need to have a way for that document to be shared with the parties so that we then have a copy of that for our records. And I don't know logistically how to accomplish that, but I would just make a request of Ms. Trennell or someone to figure out how to do that so that we all have a copy of that for our records. Thank you.
Fair point, Ms. Trennell.
The easiest and fastest way for me to do it would be to take a photo of it right now while everybody's sitting here and then I can just email that around.
All right. That satisfying, Laura? Thank you. All right. What an experience this is with the number of parties, and it's just remarkable. All right. Anybody else want to be heard at this point in time?
Are we starting at 9 tomorrow, Mr. Chairman?
Hold on. Get to that. Just want all the parties to be heard on any matter before we discuss tomorrow. Anything else for today? Okay, we have heard for requests for witness accommodation. We will do our best to do that tomorrow. Okay, so we will start at 9 a.m. tomorrow. We will, of course, start with public comment. We are going to limit public comment to 30 minutes tomorrow. It is my intention, though, past tomorrow to begin the hearings starting at 8:30, starting at Wednesday. So you're all, or Thursday, you're all on notice now that for the remainder of this proceeding, 8:30, except for tomorrow. We did have some folks contact us about the length of the lunch hour, if you will. Is there a desire to go to an hour and 15 minutes for lunch? Or is an hour enough? Hour is enough, I'm getting.
We'd appreciate an hour.
Does anybody object to an hour and 15 for lunch? All right, so you're on notice, an hour and 15 for lunch moving forward.
Question on the scheduling. If the hearing is to begin at 8:30 on Wednesday or on Thursday and Friday, public comment opportunities have been noticed for that time. Is that correct? So the public's aware that their comment period will be earlier?
So I appreciate that question. So what we will do to accommodate public comment is that we will break hard at 9 on those days to accept public comment and then move back into regular order. Thank you for that question. Other matters? Matters? All right, the time is now 5:02 PM. We will go off the record and we will pick up again at 9 AM tomorrow morning.